Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1282 et al. Advanced Energy United et al. Petitioners versus Federal Energy Regulatory Commission.
Good morning. Good morning to everybody. Mr. Shepard.
Good morning, Judge Millett, Judge Walker, Judge Childs. My name is John Shepard. I'm speaking to issues 1, 2, and 4 on behalf of the transmission provider petitioners. I've requested 2 minutes for rebuttal. May it please the court. Order 2023 imposes an unlawful regime of financial penalties to punish transmission providers, regardless of fault, for any failure to comply with extremely aggressive and arbitrary interconnection study deadlines. These penalties are significant. They amount to thousands of dollars of penalties per study per day in situations where clusters often exceed hundreds of studies on a regional basis and sometimes even in individual transmission zones. FERC's zero tolerance penalty scheme of automatic penalties is unlawful and requires vacator for many reasons, which I'll divide into 2 sets. First, the penalty scheme exceeds FERC's jurisdiction under Federal Power Act Section 206. It violates several normal principles of due process under the statutes that actually provide FERC with authority to impose penalties, and is unconstitutionally confiscatory. Second, FERC's penalty scheme falls far short of reasoned decision-making standards under the Administrative Procedure Act. It fails to meet the standard necessary to impose a nationwide rule and fails both steps under FPA Section 206, Step 1 and Step 2. The penalty scheme is worse than ineffective. It is unfairly punitive, it is unduly discriminatory, and it is counterproductive to efficient transmission planning. I'd like to begin by establishing—
The penalty scheme is not in effect yet, is that correct?
I'm sorry, ma'am?
This penalty scheme is not yet in effect?
The rule is in effect, of course, but the penalties will go into effect in the 3rd cycle.
Yeah, how long is the cycle? I don't know what a
year.
cluster study cycle is.
Think of it as basically three. You get 3 tries. That's one of the safeguards that FERC likes to say makes this not really a penalty. Doesn't change the fact that it's a penalty. What it does
Just asking a question about timing right now.
just a year.
Each cluster cycle is a year?
About, yeah.
Roughly.
Yeah.
So I'm really asking you for the information. So if you want to qualify it, qualify.
So, there are slight differences in the amount of time in each place. FERC is generally not allowed for independent entity variations, but there are some tweaks about intermediate study amounts. But I think it's fair to say, think of them as having the annual cycles. PJM, for example, will have RTEP cycle 2025, RTEP cycle 2026. They may not get finished within a year, which is the whole reason that we're here. But and if you look at, for example, when they're
When
keeping
they say
this—
a cluster study cycle, does that mean when they sort of tend to start or when they finish?
Yes, ma'am. You begin the cycle, and then you go through a bunch of intermediate gate steps.
Mm-hmm.
Each one of those intermediate gate steps has intermediate sets of penalties, and then there's also potential for penalty at the end.
Mm-hmm.
So that's about how long they last.
You kind of challenged that 100% threshold for the penalty, but is there a lower amount? Because that's going to be at the end of the cycle anyway. It's graduated penalties.
Well, what I would like to say about the penalties in terms of the amounts that they represent is I'd like to emphasize that they are confiscatory for us. But would you mind if I would like to get to confiscation second in terms of the amounts, because I want to first establish whether or not FERC has the authority to do this in the first place. Okay. So I want to begin with the punitive nature of these penalties, which FERC has always called penalties, continues to call penalties, and have all the hallmarks of a penalty. The Order 2023 sets out an explanation about why it is that FERC is adopting these penalties. And they say that it's necessary to impose penalties and dispense with the reasonable effort standard because it hasn't been a sufficient incentive in order to drive people to meet study deadlines in the time that FERC requires. However, it leaves little doubt that these are in fact penalties because it not only describes them in the manner that a penalty is described, but also imposes a regime that disallows recovery of the cost precisely because they're penalties. So there are many places they talk about it. I just direct your attention to Order 2023 at paragraphs 873 to 874, where they lay out their sort of grand theory. And in particular, the statement that consistent with other penalties, the commission proposed such penalties will not be recoverable in rates. So it's very difficult for FERC to try to characterize this as anything other than a penalty. The rule when they found new religion on rehearing in Order 2023, they tried to recast it suddenly as some sort of purely compensatory scheme, which it plainly is not. They never recanted any of their original rationale.
Oh, wait, slow down there. Okay. Do these payments, when made, go to the U.S. Treasury?
No,
No, do
They
they
do not.
go into FERC's pockets?
no,
No. They go to private parties?
yes.
Okay. All right.
Just like the disgorgement penalties in Kokesh did.
Well, no, those only went there with pursuant to a court order.
Well, the money goes to the court, and then the court does its best as far as it
Makes it
feasibly can
discretion
to get it
decide
back.
whether
Yes.
it goes or not. So,
Yes, but I don't think that's definitive.
well, I'm just saying that this, there are things, you point to some things that look like penalties to you, but there are other things that don't look.
Okay, well, let's start with the ones that
Excuse me, may I finish my sentence?
Yes, ma'am.
There are other things that do not look so much like penalties here. So it's, and we're in an unusual area here. And the rationale is that folks paid for an on-time study and didn't get one. And so they're getting their money back in some percentage for not having got what they paid for, which isn't normally how one thinks of.
Well, I certainly agree that we're not, Your Honor, in a usual space. There is nothing in the FERC world that looks like this, where you get a penalty first and
Yeah, but
appeal
you
second.
just say, well,
There's also
again, if it's not just, you said this was sort of signature penalty, and I'm just telling you that it's sort of, it has some.
I think that
some pluses and some minuses from your
the fact that the
perspective.
money goes back to the people who paid the original study deposits is maybe the only feature that makes this look anything like the penalties in Kokesh. And even then, I think that is a bit of a quibble, because the task of the district court is to try to get the money back to the plaintiffs so they can find them.
Well, I'm not quite sure how FERC would have the authority to impose something that is in fact a civil penalty, but FERC, rather than Congress, would decide where that money goes.
I certainly agree that they don't have any statutory authority to do what they're going to do. I just want to establish that this
That's not
fact
the
looks like
point that I
something
just
FERC.
raised. The point I just raised was in deciding where this is a penalty, we certainly would look at whether agencies are treating this like civil penalties that get, that are the property of the U.S.
I think they are.
To be disposed of.
They are.
U.S. government. Here, they said people have paid you money. They didn't get their pizza on time. And so they're getting some partial.
And
refund of it.
their remedy for that, Your Honor, is to take all of the money that we were paid, that we already expended to provide a mandatory service that FERC has directed us to do, and shift all of that money back to them, which is why it's confiscatory, because that never happens anywhere in the FERC world, except in the context of an imprudence finding, which we are absolutely nowhere near here. We are at best in the area of inadvertent error. But let's, if we
Test for confiscatory is, tell me what your legal test for confiscatory is?
a rate is confiscatory if it fails two different gates. First, it actually takes away your actual out-of-pocket costs. And second, still unconstitutional if, in addition to not paying your actual out-of-pocket costs, it also fails to give you a rate of return. This has been true since Bluefield.
But this isn't your money. The theory is that this is the money that these folks have paid to have this study on time, and having not given to them on time, you need to give it back to them.
We pass through the money. Transition providers pass through the money. We get their deposit from them. We pay it to employees if we have them that on staff, and only many of the larger entities have enough people on staff to begin to do the studies, but virtually everyone has to hire contractors. There are really only two contractors in the country that actually do this. They have a great deal of power. There is a great shortage of people who are capable of doing this very highly skilled work. And we have to pay a significant amount of money out of pocket. So when we give them the money back, we're at a loss, which is why one of the chief hallmarks of the fact
They're at a loss too, having not gotten what they paid for.
No, because they got a penalty that they got a study that was later than they expected, but they got a study. When I build an addition on my
Scheme
house,
they're supposed to get, the scheme is to require you to give them the study and give it on time, Or if you have a story about you couldn't find the contractors, you couldn't get them, something bad happened, then take it to FERC and let them make a case-by-case decision. But they're not going to have an across-the-board paradigm like they did before, where there was nothing to enforce timeliness.
Sure, there was. 890 had the ability to people to always seek penalties under Order 890. Why did it never happen? The behavior wasn't unreasonable enough.
Well, then I guess you got nothing to worry about in the review, if you file reviews with FERC. But
I don't think that's right, because now it's become an absolute
How many
deadline.
times are you aware of that reasonable efforts were not found under the
Zero.
scheme? That was always found as reasonable.
Zero.
So
But is
it seems like
the
not much
presumption
bite
one
to-
structure draw from that? Like,
Not
if there are
much
no
bite to that
penalties?
test. I mean, FERC could decide there's not much bite to that test because the reasonable efforts was always met, and yet studies were coming in months and months and months and years after.
I'm not sure that if no one got a traffic ticket on a particular road for a year, that the proper inference would be, we must raise the penalties in some way, because clearly people were doing bad things.
And things were coming, if everyone was driving 90 miles an hour in a 35-mile zone and over decades, there were no tickets. Nothing was done to slow down the speeding. Then I think if an agency said, we need to do something different from what we've been doing before, that would be reasonable.
Well, we were already beginning to do voluntarily many things that FERC had not allowed
But
before.
that's a different argument. So first you were denying the problem, but now if you, I said
I'm
there's a
not.
problem because you then said, now you guys recognize there was a problem too.
Yeah, before they did.
Involuntary things.
The problem, Your Honor,
But
with
the
the intersection,
agency chose a different approach.
it did, for very irrational and ill-supported reasons. So I would like to go through quickly why it is that these are penalties, because Your Honor seems to be focusing only on one thing that makes it look something not like
I
a
asked a
penalty.
question about one thing. I'm not telling
Okay.
you what I'm focused on.
Oh.
I'm asking about one thing.
Your
I promised to
question
look
seemed
at-
to
I
indicate.
promised to ask about all the factors.
All right.
Or to
So-
think about all the factors.
The holding in Kokesh is completely clear. If a civil sanction is not solely for the purpose of remediation, but can only be explained with reference to retributive or deterrent purposes, which FERC has never, ever walked away from, then under binding Supreme Court precedent, it is punishment. And that's not even a new idea. That core holding in Kokesh dates all the way back to Austin in 1993. It's an old idea. It's not a new one. There's nothing strange about this conclusion. When we march through the factors of what makes this look like a penalty, the only thing that FERC points to that's different is the money goes straight and only back to the people who paid it. What makes it different is that, for example, we're in a worse off position than we were originally, because we've given them a service and we've gotten paid nothing for it. That is not going to happen in any other context. If I build an addition on my house, I don't get to say, you know what, you're a month late, so I'm also going to pay you nothing. You're going to give me all these materials for free. All the labor was free. That's not the way it works. And FERC has recognized this since forever. At the same time, Austin was being decided in 1993. FERC was issuing its prior notice rulemaking. Very big deal. Landmark decision. It deals with the worst thing you can do in the FERC world, which is charge a rate that is not on file, that it's just made up. So you're giving me some unauthorized charge. We talk about this extensively in our reply brief. Even in that situation, FERC would never deny you your actual out-of-pocket costs. And they say that they won't do it because it's a confiscatory rate. And serious constitutional problems arise from trying to do that. That has always been the rule at FERC until now. This is the first time they're trying to take money actually out of a pocket after you provide a service that they require you to perform, Your Honor. Oh, good Lord.
But the
We're on
FBA
issue one and I
does say
only
that-
have 10 seconds left.
Well, it's all about the questions that we have, and so we'll keep you as long as we need. All right, so the FPA does provide that FERC can impose these civil penalties. So I'm trying to figure out what you think is constitutionally required before the imposition of the fees.
Well, I'm glad you asked the question, Your Honor, because FERC is saying this rule was only imposed under FPA section. I'm trying to establish the penalty because I want to get to the point that you're getting to, which is Congress knows precisely how to give FERC civil penalty authority. It does it in 6 places in the Federal Power Act, and none of those places is Federal Power Act section 206. There is no penalty authority there. This is where FERC's civil penalty authority resides. It resides in 2 sections of the original Part 1 of the Federal Power Act, the original one enacted in 1918, that only applies to hydroelectric facilities. Boom. Then we have Part 2 enacted in 1935 that gives FERC its jurisdiction over transmission and wholesale sales. The administrative pieces that go with Part 2 are in Part 3. So now leap forward to Part 3. FPA Section 315, FPA Section 316, FPA Section 316A. FPA Section 315, not really applicable. It at least mentions the word deadline, but it's only in the context of, are you sending in a report on time? Did you respond to your discovery request on time? It requires willfulness, and it's $1,000. Not really applicable here. 316, criminal referrals. No one's coming anywhere near criminal referrals. The catch-all is 316A. And 316A not only gives FERC the ability to impose a penalty, but Congress also knows how to make the process for imposing a penalty fair, because 316A has many common due process protections that are utterly absent from this rule-less weird thing that FERC has made up that has no other analog in FERC practice, to the best of my knowledge, anywhere else, where you first get assessed a penalty and then you get a hearing later, and it's not even really an appeal, as they choose to call it. It's nothing more than a request for discretionary waiver. So here are the factors. First,
I
and
think
it says
Charles had a question.
Yeah, is there a cap on the penalties in 316A?
yes,
Okay.
yes, it's very high. It's $1 million per day per violation. Very, very high. They modified that from what used to be 5,000 in 2005 when they were reacting to the California energy crisis, and they decided that they needed to up the penalties to, if you're going to go after Enron.
They can do penalties, you just think they're under the
No,
wrong
the
statute.
thing that changed in 2005 was that they increased the penalties from a very small amount, 5,000, which hadn't been changed for a very long time, and increased it to $1 million. And that was in response to the California energy
So
crisis.
they can do penalties, you just think they're under the wrong statute?
Absolutely, Your Honor. Dead on. That's exactly what we're saying. FERC says that it is
But
operating.
those penalties under 316A cover this situation.
No, because they didn't invoke 316 and it doesn't have any of the protections that go with 316. Let's enumerate what those are. First, squarely in the text of the statute, you must have a penalty, you must have a hearing and an opportunity. You must have notice and an opportunity to be heard before a penalty is even assessed, much less before you actually have to pay it.
Hey, wait, hang
Item
on.
1.
What does assessed mean?
Assess means they name what they think it's supposed to be. So FERC will issue an order to show cause first and say, we think you should have to pay this penalty. And then
What's
you
your
get an
best
opportunity to
authority?
respond.
That's what the meaning of assess is.
I'm sorry?
What's your best authority? That's the meaning of assess.
That every single assessment that FERC has ever done, assess doesn't mean you pay yet. It just means this is what you're going to be liable for, because I can march through the steps.
Do you have a court case that has said that's the meaning of assess under the Federal Power Act?
I have a bunch of court cases on appeal from FERC's penalty assessments, and you're not required to pay until you lose there. So the assessment just means, and I will be happy to provide you as many citations as you wish in a subsequent briefing, if you would like me to do it that way. It's in every case, Your Honor. The assessment means.
Normally assess means, like you said, they sort of, here's what we think you owe. But then also, at least when Congress uses the term, and that's what we're talking about here, and legal consequences attach. And legal consequences do not attach here until you either file appeal and the appeal is resolved, or you choose not to appeal.
We'll go to the one in December. This past December, FERC issued the largest civil penalty ever, just about $1 billion straight out cash, not counting interest and other things. That case is being fought about in North Carolina District Court this next week. They're not asking them to pay them $1 billion right now. There's going to be a whole process of review in federal district court. This is actually the only time federal district courts this court or Court of Appeals gets review of FERC orders in every other context, but not in the context of penalties, because district courts have the unique ability to review FERC's penalty orders de novo on the law and the facts, both. And when you are there, you get the federal rules of evidence and you get the federal rules of civil procedure. We have nothing like that here. But
I'm sorry, I'm trying to understand. Does the statutory provision that lets you go to district court say after it's assessed, you go to district court? I'm just trying to understand.
once FERC issues the assessment, you have the choice. You can pay.
Does it use the word assess?
Yes, ma'am. It uses the word assess. It seems like it must. I mean, you have the benefit of being more generally exposed to other areas of the law. I'm afraid I'm a bit of a FERC nerd. So for me, it is just very apparent that assess always means this is your liability. You can choose to pay it or you can choose to fight it. And if you choose to fight it, you're going to you can go to federal district court and you get all these procedural protections. But that's not the only one. It's actually the last one that I wanted to get to.
So if you choose to fight it, you go get a hearing and you haven't challenged the procedural protections in the hearing.
No, Your Honor, you don't get a hearing the same way because these are the distinct features. First,
Well, it may not be identical to district court.
it's not even close to identical.
I understand, but you get plenty of due process by getting to go before FERC, have a hearing, and then have judicial review of that decision. That's unconstitutional? That's shortfall in due process?
I'm trying to say that they have no authority to impose civil penalties for things that are activities under FPA Part 2 unless they're operating under 315, 316, or 316A. That's what I'm trying to say. 316A, if they are going to these are the distinctive features of 316A, which are wholly absent here. First, FERC has an investigation. You get the opportunity to act with them during the investigation. They decide that they're not convinced by your defenses during the investigative phase. They issue an order to show cause. Get an order to show cause, then you get your opportunity to say, hey, I don't think that we're guilty of this thing. Then FERC issues an assessment order. Issue the assessment order. That's when you decide, all right, am I going to pay this penalty or am I going to try to fight this further? So the statute says point blank that it requires notice and opportunity hearing before assessing any penalties. That is item 1. Item number 2, every one of the other penalty statutes that FERC has a mens rea requirement. None of them are strict liability. Almost all of them are willful. In fact, in terms of the statutory text, they're always willful or purposeful conduct. But FERC issued Order 640, and 640 says in the specific context of market manipulation, it can be something less. It can be recklessness. We are not anywhere near the realm of recklessness here. We're talking about inadvertent errors and things that we cannot control. That's item 2. Item 3, in all of these cases, the burden of show is on FERC. It is not on the civil penalty target. And as we were just discussing, if you think that FERC has screwed up and you think you've got a good case for appeal, you go to a federal district court and you have a de novo trial on the facts, on the law, in federal district court with federal rules of evidence and federal rules of civil procedure. None of that is present here.
You think it's a civil penalty? Does FERC think it's a civil penalty?
No, they spent a lot of time trying to say
that's what I thought. So imagine that FERC had done this instead. Said the deadline's 150 days. And if you miss that deadline, you owe the interconnection customer whatever they've lost from your delay. Would that be a civil penalty?
I think if we had, I think that you would need a hearing to figure out these things. Are we responsible or are they? That's a big deal here because FERC squarely says that even if we were to show in their beautiful new appeal process that the transmission first customer was at fault, they would still make us pay.
If what you're saying is necessary to answering whether it's a civil penalty, then
don't
forget the question was this thing I described.
Yeah.
Is it a civil penalty?
I'm working through it. I think that it. Yes, because we're gonna have to fork over the money, and
it seems awfully compensatory what I described.
Yeah, but
almost the definition of.
I think without a limit to me. That's exactly, if I'm pausing because that's exactly why I'm not willing to concede that would not be a civil penalty because it would still be confiscatory. And I'm working through your this is an excellent question. I'm glad you've asked it. I think it's important to your decision to pursue it. I think that might not be a civil penalty.
Okay.
But I feel I have some misgivings about that, but I'm having trouble identifying what they are. So if you would not treat it as a concession now in the event that I have something better to answer on why, but I think we can proceed that way.
I appreciate being cautious about making concessions. So I'm my next question is not I'm not asking it for the sake of tricking you. I'm trying to think through whether what actually happened here is a civil penalty or not. I know you very much believe that it is. What would make this system a civil penalty that would make the system I described possibly not a civil penalty?
Well, this way, and we've kind of omitted like a bunch of fact finding in what you've described. And here's a similarity. There's a deadline. We've got a penalty associated with missing the deadline, and we've got money going back. Those are the things that are in common. What I don't know from your scheme, which is I'm having trouble trying to figure out how to classify it, is did I ever get a chance to say whether or not, I mean, did I ever get a chance to say that is this a strict liability thing or not? Because even when you structured that, you said you'll have to pay based on how much damage that they've suffered.
The hypothetical will probably hold everything constant, except the amount of money that you owe. And I understand in the current system, you owe a somewhat fixed amount for each day of the delay.
Yep.
But in the system I'm suggesting, a fact finder would inquire into, hey, how much money would the interconnection customer have if you had been on time?
That begins, Your Honor, I think
lose because you were late.
So then it begins to look much more like a traditional rate case, because let's take, for example, when Winter Storm Elliott happened in 2022, PJM system, other systems go down. Well, actually, PJM system stayed online, but it was there was a massive capacity shortfall. And we spent a year trying to figure out who's going to pay $2 billion in penalties. And the tariff there says, okay, if you have a capacity commitment and then you fail to perform, then you're going to owe this much money. And the amount was drafted into the tariff. But we then had to litigate for a year and ultimately reached a global settlement between 108 parties to figure out what people were going to pay, because we had very different perspectives about who was really at fault in each individual case. So there are tariffs and that have exchanges of money going back and forth depending on different circumstances. Like if I put in my bid before a certain time and I don't change it before the clock runs out, I really can't change it, and I might be stuck with with having just made an offer that was double the capacity of my plant. So
would my hypothetical cost you more or less money than what?
Your hypothetical would certainly cost less, and I think it's important to submit. Yes,
my hypothetical would include all the lost profits that the interconnection customer is not making.
Yeah. So, and this is why I'm quite confident that we're worse off, because in my situation, in the situation we got here, I'm having to give them back money I've already spent and paid experts to go do something. Here, I'm going to have a fight about their consequential damages. But remember, nobody's putting iron in the ground until they've gone through this process. So, and that's one of the reasons why it's so strange to try to, FERC never even tried to figure out what the damages would be for someone who, like in PJM, there's a 3-year out time period for capacity, to bring on a new plant capacity that you get the obligation in auction and you deliver it later. I'm not sure that someone's going to be very successful at showing sort of consequential damages if you have, because let's even plug in the 10-day grace period. So you're at day 11 and now you're going to have to pay a penalty. And in the world where you get to base it on their consequential damages of the lateness, when their commercial operation date is 2.5 years in the future, I think it's very, very hard to say that they weren't able to actually come online during that time.
I want to switch gears a little bit.
Okay.
Well, I just wanted to ask about, you keep trying to get us to suggest that this is a penalty, but why isn't it just not a limitation on the amount you can recover from the study?
Because there is no other context in which a utility expends funds to perform a mandatory service FERC requires it to do, and they earn nothing on it except one. And that is in the context of an imprudence finding, which is a very unusual and rare remedy, which is when a utility somehow engages in behavior that is so bad that it is per se unreasonable. And this is like building a transmission line to the middle of the ocean with connecting to nothing, kind of that kind of thing. That's what imprudence is. It's a pretty difficult standard to meet, and you have to look all the way back, I think, to Millett v. FERC, like 1988.
But generally, FERC gets to deal with its noncompliance.
FERC gets to deal with issues of noncompliance?
Yes.
Yeah, deal with issues of noncompliance all the time. And so someone will bring a complaint, and they'll bring a complaint under Section 206, and they'll say, we think you did a bad thing because, and after we have this, there will be a hearing. Typically, it's a paper hearing. FERC will issue an order, we'll get an opportunity to have a rehearing, and there we go. Here, we're going to pay the penalty right now, and then we're going to go into this appeal process. And this appeal process looks nothing like what I just described.
If you appeal, you don't have to pay the penalty.
You don't have to pay the penalty until you eventually lose. But I think if you were
Okay,
faced,
but I'm sorry, I thought did I mishear you? I thought you just said you pay it and then you go into this appeal process.
no, I'm sorry that I misspoke.
Maybe I
You're assessed the penalty,
Mhm.
and unless you take this thing FERC calls an appeal, which I would call a petition for discretionary waiver under this good cause standard, unless they give you mercy, you're going to pay. I don't think that any accountant would ever treat this liability as anything other than a cost you're facing. I think the SEC might have some concerns if you had a 6, 7, or 8 figure penalty.
You're getting way down the line here. We haven't seen this scheme in operation.
No, we
don't
have
know
not.
we don't know that, I'm talking about ripeness here. We don't know. You've got a view that it's this automatic loss thing.
Yeah.
And that's your surmise. I suspect FERC will say, no, we will look carefully at the record in each case and make a decision based on the facts.
I think we have good reasons.
And then, I'm just going to finish here, and then we'll make a decision that's subject to judicial review.
Your Honor, I think we have absolutely excellent reasons for being very suspicious about our prospects under this strange good cause so-called appeal rule first. There are 0 procedures that we know about it. The entirety of the procedures that FERC has created are reproduced in a block quote in the middle of page 7 of our reply brief. It is 3 sentences long. You have 45 days to bring an appeal. You have 45 days to pay if you lose the appeal or at the exhaustion of whatever other remedies you have. And the 3rd sentence says, we may choose to excuse the penalty for good cause. That is all of our guidance we don't know about.
Well, they have existing
Witnesses.
hearing procedures already on the books. And
Not for this weird thing.
well, wouldn't you just fall into their existing procedure?
No, we don't even know. We don't know if we're going in front of an ALJ or if we're going to have a paper hearing in front of the commission. We don't know. We know nothing about this process because FERC prefers to develop it ad hoc. I think that regulated entities have reasonable grounds for suspicion about a process that they know none of the rules about. It's very hard to order your commercial
It
decisions.
just seems like we're sort of getting out over at least our skis, maybe not yours for worrying, but ours legally. I don't know how we could declare
Well, here's,
improper or something that we haven't yet seen in work.
Because
And
FERC's
so I
already-
assume what you will do is
because
you will
FERC's
pick
already-
you will pick which route you want, an ALJ or FERC, and you'll make a filing there and they'll say right or wrong and then shift it to the other forum and then you'll make your presentations and a record will be created.
problem 1, we have no procedures. Problem 2, we have no coherent standard. No one knows what good cause
Imagine
means.
you got one of these penalties tomorrow.
Okay.
Exact same world we're in right now, tomorrow. Or your client did, not you personally, your client did.
Understood.
And your client says, I want to challenge this.
Mhm.
Would you say, I don't know what to do? Or would you say, well, there's
If
got two
I'm-
options here. I'm going to pick the one that I think.
If I'm gonna pioneer this, I'm gonna do what we do. FERC also has no procedures whenever this court issues a remand, which is why it could sometimes take a long time. So what I would look back in that bag of tricks that I've used before, and I would file a motion with FERC saying, hey, I move to use these procedures on remand from this court's decision. So I would try to invent them, and FERC is going to have to invent something, but no one wants to be the person who's pioneering these things.
You have a way to get to FERC and say, and challenge the penalty. You're not disputing that. You're saying.
No, I'm not
we don't
denying.
have a federal rules of.
Right. I'm not denying that they have said you are going to, you can ask us for this relief. They haven't given us any rules for the relief, and they've got this weird good cause standard, and we don't know what it means. And so we keep asking them, what's this good cause standard means? Because we haven't seen this thing before in this context. There is a context, there are 2 contexts that you use good cause. One is if someone wants to ask in advance for a shortening of the statutory notice period, and it says in the statute, this is where this comes from, this verbiage, that you usually have to file a new rate at least 60 days in advance. And FERC will let you shorten that time period for good cause. You want to intervene late, good cause. You need a waiver, you get a 4-part. You go through a 4-part waiver test. We asked them, will the 4-part waiver test apply? They said no. But again, why are we suspicious about this? Because what FERC has told us about what is going to happen doesn't give us a great deal of faith. They have told us in Order 2023, and I will happy to give you all the J sites if you want them. It does not, the fact that it's force majeure doesn't mean that we're excused. The fact that they can't determine.
Needed, of course, they're going to review the circumstances and listen to it. I mean,
They've told us.
It says force majeure, you're going to say, well,
Your Honor, they didn't,
Your office is affected.
Your Honor, they didn't say, we'll figure out whether or not it really is
We'll
force
figure out
majeure.
that answer in an actual case.
Okay. The second question, second example is it doesn't matter what the cause of the penalty is, but the actual clincher is when we said, what happens if, as we suspect will nearly always be the case, the cause of the problem is the transmission customer. They failed to give us information on time as a transmission, as a utility. We then, if you're an RTO, we need to pass it on to the RTO. We missed their gate because they missed our gate. And we come in and we say, so assume that we have shown that the transmission customer is at fault. And what did FERC tell us there? That could potentially be exculpatory. That's like the best possible case we could put on, where the other guy we're supposed to be paying money to is the negligent party involved. And they said, we don't know. I don't know. No one wants to go into an ad hoc procedure like that.
Well, it might mean exactly what you've said, which would be, hard to understand how they would reason that. Or it might mean when they say, we'll see whether we're going to make facts about who really was exculpatory and who had how much control and how much that thing caused the delay versus 12 other things caused the delays, which is why, again, it seems like all of this.
No, Your Honor, they're very clear about one thing. They're very clear about the fact that transmission customer is never, ever paying if there's any sort of lateness.
Again, that's your prediction.
It's not my prediction. It's what they say. Again, let's please.
Where do they say transmission customers won't ever pay?
Yep,
I mean, that's a different point altogether. Are you claiming that you have a right to payments from transmission customers?
No, I meant to say that we are never allowed to keep any money from them if there is. Let me just read to you exactly what they say. So there's no reason to doubt the words. All right. They say, and this is exactly what I was covering earlier. This is in. Good Lord, I need to put my glasses back on. Paragraphs 873 and 874 of order number 2023. It's at J 1999 and 2000. And
sorry, tell me those page numbers again.
All right. So consistent.
Sorry, what are the JA pages?
1999 and 2000. It's paragraphs 873 and 874. So they say consistent with other penalties. Well, Your Honor asked the question earlier. They say they divide their civil penalties. It's weird because they definitely say they're penalties repeatedly. Right. So, consistent with other penalties, the commission proposed that such penalties will not be recoverable in transmission rates. They're very clear that we can't.
Can you just slow down?
Sure.
I think I might be. You said JA 1919?
1999 to 2000.
That's my fault. I heard.
It's going to party like it's 1999.
Okay. That's my fault.
I guess I just dated myself.
1999, 2000. You said paragraphs.
It's 873 and 874.
Okay, got you now. I'm with the same place you are. Okay.
Consistent with other penalties, the commission proposed that such penalties will not be recoverable in transmission rates. And they say this several times, Your Honor.
So I want to make sure I'm finding. So, sorry, 1919 to 2000 is describing the NPRM.
That's right.
There's something wrong with me. I'm not seeing.
Yeah. So they're,
Is it carrying over from the?
Yes.
What?
I'm
not finding it. I'm sorry. And I'm sure this is my fault. I'm just not finding. Are you starting?
This I'm positive is a quote. Consistent with other penalties, the commission proposed such penalties would not be recoverable in transmission rates. That's perfectly consistent with the fact they were describing the number.
I'm sure it's here. I'm just not.
Other trigger words in front of it, reasonable effort standard did not provide meaningful incentive to comply with deadlines. And then move on.
Oh, sorry, consistent with other penalties, commission proposed that such penalties would not be recoverable in transmission rates?
Yes.
Okay.
That means we can't
I thought you said
come back.
Customer, I thought you started this by saying the customers would never have to pay anything. I thought when
trying to say that whatever.
I thought you meant the interconnecting customer.
Yes, I'm trying. Well, we can't recover them from ultimate customers in transmission rates. And to direct your attention to another place, which is order number 2023 at paragraph 993, JA 2074.
Wait, let me catch up to you. 993?
Yep.
Okay.
It's a very, very big record.
993 you said?
Yes, ma'am. It is paragraph 993 of Order 2023. It
What's
is
the
JA
JA?
2074.
2074. Okay. Sorry, when they say transmission customers, does that mean interconnection customer or?
Interconnection customer is the way I would refer to the people who are the transmission
Okay.
or the generation
So I understand.
developers.
So when you said the customer's never going to pay.
Yeah, well, we know
I
that
thought you meant the interconnection customer.
we-
You said.
we know that.
Cost the delay.
So yeah, that's this one. This one is the one where we're
Okay,
saying,
and I'm saying-
so let's say the interconnection customer is the one who is at fault.
Okay.
That's the one where we thought, okay, this is our best case. Like surely they're going to let us go on this one, right? At least contributory negligence, something like that. And they say, nope, that's just a potential basis for doing this. Look for the words potentially compelling basis. We thought that was maybe going to be a shoe-in. Might have made us not come here. Who knows? As far as transmission rates are concerned, what that means is if we get a penalty here, there are situations where utilities pay penalties. Often when they have costs, those things become a regulatory asset. You put them in your rates, you recover for them, unless they're imprudent. Again, the rare case when it's imprudent. When you say that you're not allowed to recover something in transmission rates, what they mean is that you and I, as retail customers at the end of the food chain, aren't paying anything. The LSEs that were making wholesale power
So your whole point is about this, if a study delay is caused by the interconnection customer, not a rate customer.
Yeah.
And not the transmission provider, that would present a potentially compelling basis for the commission to find that good cause exists. And you don't like that because it has the word potentially.
Absolutely.
But what's wrong with, I mean, if I said, if you come here and tell me that somebody did something wrong, you're going to win, full stop. I wouldn't be a very good judge because I would say, well, I will definitely hear that. And that sounds like an important circumstance, but I do want to hear from the other party as to whether that happened and whether there were a multitude of causes here that caused the delay. I mean, I think that isn't that all potentially means there? They can't come out right out and say, if you tell us that, then we're going to automatically rule for you.
I think there's really no mistaking the commission's tenor about whether or not this is going to happen. I think it is incompatible to think of them as ever being anything other than excused for a late study when the entire remedy is to give them back all of the money, regardless of whether or not they actually suffered any damages in any measurable way.
With all the money? I thought it was.
No, this is for each phase, right? We're going through. I mean, yes, Your Honor. If you pass a certain point, you are giving them back all their money.
When
Like
it's
that doesn't.
Depending on the length of the delay.
Yes, exactly. So.
But no doubt that FERC can regulate its rates and provide these certain incentives that you are not calling penalties so that we can deal with this breakdown in the system and the queue and all of that.
I'm saying they cannot do it under 206.
Okay.
I think we'd be in a very, very different world if, to use a slightly different thing than what Judge Walker was postulating, which I expected we might
So
want
is
to
that
talking about.
an admission that even if we were to vacate the penalties, that you agree that the rest of the rule stays in place?
Well, the other people are fighting the rest of the rule. The only thing we're fighting here is penalties. And let me sharpen this point this way. But you're aware from the record that there were early adopters. Some RTOs pioneered the idea of abandoning the rule that FERC put in place, the serial study procedures they had under 2003, which was never built to deal with the numeracy of the interconnection requests we have right now. That was back in the era of we're going to go build a great big natural gas plant here, a great big coal plant here, or possibly a nuclear plant. Now we're deluged with all these other things. 2003 serial study, doing it one at a time, was never meant to that, and it lasted too long. So people began to pioneer this idea of using cluster studies. As soon as they prove to be successful, you immediately start to see these drops. It starts spreading like wildfire. Every RTO had adopted cluster studies by the time the final rule was even entered. The difference between the cluster studies that FERC imposed in the bulk of its rule, the part that we're not challenging, and in each case, FERC continually found it to be just and reasonable for us to do this, is that they layered on something extra in the rule. The only thing that's new or interesting about the rule, as far as we're concerned, because we were voluntarily pursuing cluster studies because we want to get things built because that's the only way we get paid if we're a for-profit entity. And if you're an RTO, you have no incentive whatsoever to slow anything down because you are subject to mandatory reliability penalties if you fail on reliability, but you have no financial stake at all. The only thing you care about is operating clean grid. So there is no incentive, and FERC never says anyone has any incentive to actually slow anything down. In fact, they go out of their way to say that they're not impugning anyone's past conduct. That's one of the main points in an arbitrary capricious piece, is that there is zero evidence of any misconduct that would ever amount to a penalty. So everyone's already doing this voluntarily because we have our interests are utterly aligned and that we want the interconnection queue fixed. The problem was never anyone's behavior on the transmission planning side. The problem was there was no discipline on the size of the queue. We've gotten better about figuring out ways to do that. We talk about the fact that MISO figured out a way to choke off the mess because, Your Honor, we were living in a world until people started imposing these cluster study processes where there's more in the interconnection queue than there is installed capacity in this country. MISO was remarkably successful in doing what I think was a very common sense measure. We talk about this in our brief, where they got FERC to agree that can't we just cap each cluster at 50% of the installed capacity we already have? Isn't that a reasonable limit, the number of things we have to go after? Because there were two values in what FERC was doing. They were so concerned about open access and treating everyone exactly fairly, regardless of the nature of the thing, regardless of how big they were. It was very important to them that everyone be treated equally. But eventually you begin to have to make some hard choices about who's real and who's not real. You have the federal government and certain states giving all kinds of subsidies to encourage renewables because people sincerely believe that without renewables, we have too much carbon and we're all going to die. We're not debating that, right?
Point.
So, yeah.
Probably a 30.
So the only thing we have new is penalties. That's it.
Okay.
From Judge Stetson.
So I think you will like some of these questions because they are about just how the system works, how FERC works. These are FERC nerd questions.
Okay.
From a non-FERC nerd.
Get there, sir. Promise.
Let's start with who pays a transmission provider when the transmission provider transmits power.
There can be instances where the generator pays for that, but typically the costs go to load, the ultimate consumer, so it passes on through. So you seem very surprised. So maybe I misunderstood your question.
Well, I'm surprised that the guy who pays his electricity bill is writing a check to MISO. I don't think.
No. So that's what I was trying to say ultimately. So if you're in an RTO, then you are going to pay the central price for the power that you're buying. The transmission piece will be one component of it, and it will then flow on through your actual utility and then ultimately to the consumer.
Okay, so if it is a system operator, an RTO or an ISO, mm-hmm. then that system operator is transmitting power.
Yeah.
And who is writing them the check for transmitting the power?
The purchasing load serving entity is writing a check.
Like the local.
And if yes, right. But if you're outside, let's say you're in a vertically integrated utility outside an RTO, that means you have the generation piece or the transmission piece and the distribution piece. Then the transmission piece will be part of the bill that you were sending down. Look, even if you're inside an RTO,
it will be part of the bill that you send to
the ultimate consumer. There's a transmission component in each one of these things.
Okay.
So it goes initially there and then it passes on through. And like FERC's whole theory for the rule, remember, okay.
And this is just a terminology question. I know what we call system operators. What do we call the transmission owning providers? Is that what we're supposed to call them?
Well, FERC likes to use the term here, transmission providers, as a pay stall for whoever is providing transmission service, whether you're inside an RTO or not. If you're in an RTO, the operational control of the system goes to the RTO. That's what makes it an RTO.
Got that.
If you're not in an RTO, it's this other guy.
And
but even in
called
an investor-owned utility, an IOU, or possibly it could be a cooperative or municipal utility, which aren't FERC regulated.
I'm just wondering, like, when we write this opinion, what word are we supposed to use?
I would use load serving entity. That's a good catch-all for the person who's ultimately responsible for getting power to your house.
Okay.
That's the person in between the wholesale market and you. That's a catch-all term that I would use.
Okay, a load serving entity.
Yeah.
Okay, and they are your clients.
They're my clients, and RTOs are also my clients. Yeah.
Okay, so now I want to ask about how, whether it's load serving entities or system operators, I want to ask about how they are going to pay for the cost of doing studies faster than they used to do them. So,
Yeah.
these might be friendly questions.
I'm delighted to talk about this.
One question, one thing I take that they cannot do if they are load serving entities is they cannot just incur the late fee and then make the customer pay for the late fee. Right? That's what you and Judge Millett were talking about.
So certainly the interconnection customer's not paying for it. And then if you do pay a penalty, you can't then go try to recover it by sending it through as a component of your transmission rates. It's not meant to go to customers.
Okay, that's the penalty.
Yeah.
Now, you could hypothetically avoid the late penalty by throwing an enormous amount of resources at these studies.
Yes.
So that they're done really fast. And they're
yes, you could. And do you know who pays for that? The consumers do, because now it becomes a regulatory asset because you're doing a prudent thing.
Interconnection customers, is that right? It's the interconnection customers.
Well, they're paying.
Yes or no? Is it the interconnection customers?
They're paying for a study, but the study is the study.
The order says
the employees.
The order says in terms that the costs of increased resources being poured into the speed up process will be passed on to interconnection customers. Are you telling me that's factually inaccurate?
I'm trying to say this. A person comes and pays for a particular service. They want this interconnection study done. I've understood Judge Walker to be asking the question, if an RTO or an LSC goes out and gets a bunch of extra people, they don't exist, by the way. There's plenty of record evidence about how hard it is to get these people. If they go and get those people on as employees, and that's a prudent thing for them to do, particularly when FERC just direct them to do that, then those costs that they incur to provide that service become part of the applicable transmission rates. There is a giant section of the 18 CFR that's uniform accounts.
I think that is the answer to my question. So, and kind of since merging that with Judge Millett's question and your answer to her, when an interconnection customer comes along and wants a study, the load serving entity says, here's the cost of that study, and the interconnection customer pays that cost. And I'm guessing that cost is capped by FERC.
Yeah, we now know what the schedule is.
Okay,
yes.
that's okay. And if, in order to meet the deadline, the load serving entity has to.
It can vary. There's independent variations. They don't have to be exactly uniform, but yes, it will be fixed in a tariff that FERC will approve. That's probably the best way to describe it.
Okay. So, but in order to go super fast and make sure that you never miss those deadlines, you might have to spend more money. Lots more money than you're getting from the interconnection customer when the customer pays for the study. I think you want that answer to be yes. I think the answer is
yes. It is. Okay. It is surely yes.
Okay. And in order to hire all those new people, hypothetically, the transmission provider would pass that extra charge on to the consumer.
It would become a component of their rate per transmission, which is a cost of service rate. There are lots of different boxes that you go into. Cost of fuel goes here. Okay. Cost of hardware goes here. This would be one of those things, labor. Okay.
And would that rate have to be approved by FERC in a 205 filing?
Broadly speaking, yes. But in practice, what happens now is people file formula rates, and y'all have approved this, which have a methodology for setting the rates, but they don't tell you the exact number. And so after you have finished you true them up. And so you have a kind of an estimate, but then you kind of true it up later. But all the components are already in the rate. You just sort of fill in the number. Like maybe this one changed and this one's the same. But yes, it's like a matrix. And you're like, okay, was this much? No, it's this much.
Okay. That's all what I guessed, sort of. Yeah. And it's helpful to get it confirmed. And when FERC's up here, I'll just double check with FERC that they say that's how it works as well. I suspect they will. Now, on the sort of legal point, the analysis here, it seems like it's somewhat reasonable what FERC is doing. And here you'll disagree. So let me tell you why it seems reasonable to me, and you tell me why you think it's not reasonable.
Yes, sir.
the consumers, hopefully, hypothetically, theoretically, will benefit when there's more supply than there is now. Because if demand holds steady and supply goes up,
You'd expect
prices
to
will
go
go
down.
down. Right? So since the consumers' prices are going to go down when all this new supply comes online, seems pretty fair that the consumers should ultimately sort of pay the cost of getting it online really fast. And they're not paying the cost directly, but as you just described, the beneficiaries of this system where the interconnection customers get online faster, the beneficiaries being the consumers, will pay for the cost of getting it online faster.
Connor, you are dead on right. And I've been able to proceed according to my roadmap. I would have been talking about this under whether or not FERC shows whether and how these things are directly affected by rates. You're exactly right about what FERC's theory is, that the whole reason why they feel that they need to be so severe about, down to the day on when these things are done is because we need to get this stuff in the ground so we can increase supply, so we can cause consumers' rates to go down. It has always struck me as insane that they then say that the consumer doesn't pay for it because the rule is cost causation and its corollary beneficiary pays. So if, as FERC says, the ultimate beneficiary of this entire rule is the ultimate consumer, then heck yes, they should be paying for the things that we do that are prudent. Now, if you hire a million people and you only need 50, that's probably not prudent.
And they will pay. You'll charge them more and they'll pay.
But what we can't do under this regime is fail to meet this spot.
You can't charge them more for the late fees,
Yeah.
but you can charge them more for the increased costs
Yes,
of
we
going
could.
fast so that you never have late
That
fees.
is absolutely true. But you know what our limitation is there, Your Honor? We don't have any engineers to hire. They are absolutely impossible to find. Dominion's got this excellent affidavit where they calculate to the day how long it finds to even find a candidate.
Wild numbers, but I imagined if you started telling engineers you will pay them $1 billion a year to work for you,
Yeah.
then there would very quickly be some engineers
Yeah.
who stop doing what they're doing and start doing this, and then you would pass that $1 billion cost on to the customer.
Yes, and then the minute that you do that, the Maryland Office of People's Counsel, the New Jersey Office of Rate Counsel, the consumer advocate groups, the Ohio Consumer Council, all these people will come in and tell you that what you've done is raping and pillaging consumers. We fight about these kinds of things all the time. But when we do,
I think that seems to me like a fight you should win.
yeah.
And that is not the fight before us.
I agree that that's not the fight that's before us, except that FERC tells us when we say we can't do this thing, they try to fiat into existence better and higher computing power and try to fiat into existence a highly skilled labor force that does not exist in the numbers we need to process them. 2 companies in the country do this. If you can't source it internally, and they make you pay a lot of money to do it.
All right.
I don't think I've ever gotten to discuss anything about the arbitrary capricious point.
Can
Yes.
I just one last question? I think we kept you up a very long time.
Yes.
FERC says, it feels to me like a sort of extreme view. FERC says the old system, reasonable efforts, not working, not good enough, extraordinary delays. And so they adopt a policy here, which you say that's overkill. So
Good.
under
So glad you asked the question. I see where you're going. Yes.
you say it's overkill.
Mhm.
What did your clients propose as something more than reasonable effort, something in between as a standard here for performance?
I think we were perfectly content with reasonable efforts, and I don't
Did you
agree.
propose, so you didn't, your clients did not propose anything in the record?
No, we were mostly fighting a defensive battle against an offensive war
Okay.
here, but
All right.
the
That was my question. I just want to know if in the record you guys had proposed an alternative mechanism, something sort of halfway in between.
no, we were content with 890. Our problem was that FERC never put in any evidence of anything at all in terms of causation. They have evidence that study
That's not my
delays
question
exist.
anymore. I'm just asking the question whether your clients had proposed an in-between standard, and it sounds like the answer.
If one of the comments from one of the transmission providers talked about that, I've forgotten about it. And
Okay.
if I learn that I'm wrong, I will let you know
Right. Perfect.
on rebuttal.
Thank you.
And then just quickly, the takings and due process arguments, Were those raised in rehearing? Because FERC did have an
Yes, Your Honor.
document that
Yes.
you can't raise those arguments for the
Right.
first time on rehearing.
That's what they said. And Your Honor, I think you might remember from your Duke Energy Progress decision, they tried this same gamble here where they said we typically prefer to hear about arguments before we hear about them first time on rehearing. But and though Your Honor didn't cite this because you just made the decision on first principles, and thank you, that was a heck of a public service. We appreciate it. This court has held since 1981, which is the same time, the language they cite in Rule 313 also came in the same year, so they're both 40 years old. But in cities of villages of Chatham in 1981, this court squarely says, and we quote it in the reply brief fully. The statutory text plainly states that aggrieved parties may bring novel arguments to the position of the tension up to and including their rehearing request. This attempt to try to put us into a position, especially in the context of a rulemaking proceeding, to forecast what potential errors might ever happen on a final rule, that has never been a requirement before. It may be administratively convenient for FERC, but it doesn't say anything like that in FPA Section 313A. In fact, FPA Section 313B says if you've got a good reason, you can actually, it's a very strict preservation requirement, but under 313B, you can show just cause why you couldn't have raised the argument earlier. You can even bring it up for the first time on appeal. And all this is pretty well settled law.
Referring from FERC's general authority under 206, saying that instead they should go under 315, 316, 316.
Oh, I think we're missing so that's about whether or not they have civil penalty authority anywhere under 206. They do not. You're talking about, I thought you were asking about their argument that we had to preserve our arguments raised on rehearing at some time earlier than rehearing.
Takings and due process.
Right. And they tried that. Yes, they did. That's exactly what they argued. And we're saying that has never been the law. It is crystal clear it's not the law in this circuit. Cities of villages of Chatham said that in 1981. We've got an entire string cite in the reply brief of all the other many times that happened. And Your Honor didn't even need to rely on those cases to reach the correct conclusion. The Duke Energy case, you just figured it out from first principles and said, heck no, I don't care what you think you typically prefer. There's nothing that says people can't raise it. And this is when you know FERC is in trouble, when they manufacture these kind of nutty, simultaneous, you failed to preserve and also it's moot. And I know, Your Honor, Judge Millett, you had mentioned this question, whether or not we were premature. We're not. Right? MedImmune and many other cases are crystal clear that you don't have to wait in order to challenge the constitutionality of a penalty until they actually levy it on you. So we're certainly here now appropriately. And I don't know how else to read the law on that subject. We have every right to challenge
You're in
the
the position
Constitution.
of, you can meet all the elements of pre-enforcement challenges is your position.
I think so.
Okay. I know you said you wanted to talk about arbitrary and capricious, and we have had a lot of questions for you as we're trying to
Well,
learn what you already know. So what I
thank
will
you.
do, if my colleagues are okay with this, is give you just a couple minutes,
I'll be
because then they can address it.
Yes, ma'am.
And you'll have a chance, if you choose on rebuttal, to come back to it. I don't want to cut off all discussion.
I'll be super fast about why this rule makes no sense because we've covered a lot of pieces of it and it'll be easy, I think, to weave them together. This entire thing is premised on the idea that there's evidence that there are such a thing as study delays. We have there's the table, Appendix B of Order 2023 has all the data about this. I would submit that if you look at that data, you will see that everyone who started voluntarily adopting cluster studies was already showing significant gains. There is zero evidence that anyone, and for deliberate, very pointedly runs away from ever trying to tag any particular person with any errors. So we have an unjust, unreasonable condition, but no cause of the condition, because FERC does not want to look in the mirror and say, we might have kept Order 2003 on a little bit too long. And that's the mess that we're still trying to clean up. So then they decide that they're going to now have to layer on the penalties here. And because they decide they're going to lay on the penalties because they're aiming at the wrong problem, which is training to time, not to standard, they fail under step one because they never identify the cause. They fail under step two because imposing a penalty for delays is never, ever, as we have said in all of our pleadings below to FERC, and as we repeatedly say in our briefs here, we are going to eat a study delay penalty every single day if it means that we are going to have reliable studies. There is always a tension between any deadline and quality. It presents itself every time you write an opinion. It presents itself every time FERC is on rehearing. It's very difficult for FERC to act like there is no tension between these things when, as in this case and so many others, they failed to meet a statutory deadline to file a rehearing order and then come to you and say, can you please give us some more time because we really want to get this right and be able to deal with this. That's our position. There is nobody, and FERC never says anyone has an incentive to do anything other than get this done on time. RTOs have no incentive whatsoever financially on anybody's side. The only thing they care about is operational excellence, and it's very dear to them. If you are a TO inside of an RTO, and you're going to be in two different kinds. Many transmission owners now are what we call pure wires company. They divest themselves of generation. First Energy split off First Energy Solutions. Exelon used to also include Constellation. They sort of like reverse merger and rip them all apart. If you're a wires company, and if you're a wires only company, you only do transmission distribution. Many companies are like that now. Your interests exactly align with the generation developer because your only way to get paid money if you're a wires only company is to build wires. So you want them to come on. You need them to come on so you can make more money. That leaves only one other population of people, and that's vertically integrated utilities. Let's subdivide them into their two different brackets. You're
at your time. You're
a vertically integrated utility. You're inside an RTO. You are in an absolutely public process. You are bare naked. Everyone can see everything, every jot and tittle of your body. They know about it. You are not going to go away with any shenanigans. If you are a TO outside of an RTO, that means you're going to be subject to a state integrated resource plan, and you wouldn't have asked for somebody to come onto your system to provide generation unless the state allowed you to do an RFP to do that, because all that goes in a rate base. So there is no way you're going to get crosswise with your state regulator, who actually has more control of your purse strings than FERC does, by slowing down a project they RFP'd that you need to do in order to serve your native load. This is for all those areas out west. And that's why I think you'll see all these zeros. People outside of those RTOs, look at the zeros.
Okay.
No failures.
Questions on this issue?
No.
You said that at step one, FERC didn't identify the cause of the problem.
They misidentified the cause of the problem. Yes.
Well, how is it possible that the problem of transmission providers taking a long time to do studies is at least not partly that the transmission providers didn't go faster?
Because they never disciplined the size of the queue. It has included for many years people we were not allowed to exclude that were thoroughly speculative.
That could be one factor, maybe even the biggest factor for why these studies have taken as long as they have.
Your Honor.
But surely another factor is if the transmission providers had thrown more money at the problem, it would have gone faster.
It is possible if we could find the labor supply, we could have made it go faster. Everyone here, as I've just explained, is interested in getting it faster. You have correctly recognized that in order to make that investment, the ultimate consumers would probably, at least up front, have to pay more. But the real issue has always been the size of the queue. And now that we've got a way of managing group projects and aren't doing everything serially, I think we're on a real road to recovery. It's going to get better.
Putting aside where the funding will ultimately come from, would you agree that the entities that are in the best position to make sure, let me rephrase, the entities that are in the best position to speed up the studies are the entities that are doing the studies?
That is true, but we are never, ever going to meet a deadline to try to avoid this penalty if it means we're going to run up against the really things we care about, which are FERC's other set of mandatory penalties for reliability. That's reputational stuff. That's the core of the mission. That's good utility practice. That's what we're here to do. This is not some situation where we're trying to soak people. We actually all want the same thing. And if FERC would get out of the way and let us solve it, we'd solve it. But their insistence on having to treat everyone as if they're the exact same quality, that a solar plant, which can only deliver for half the day, is the same thing as a 1,700 megawatt natural gas plant that produces energy on demand. That's nonsense. And having to pretend that was not nonsense for a very long time meant that we had this huge stack of queues. Production tax credit's gone now. queues are beginning to thin. The speculative projects are beginning to wane out. I think I see a road to recovery up here. Sticking us with penalties while we're trying to get there, that is foolish. All it does is result in finger pointing. No one is cooperating anymore because everyone's worried about who's going to pay the dang penalty.
Get there, not on the Christmas list.
Thank you very
All right,
much.
thank you very much. And we'll give you some time for rebuttal.
Thank you, ma'am.
Wayne.
Good morning. May it please the court. I'm Albert Lin, and I'm here to address some of the arguments unique to the nonprofit system operators. I'd like to reserve 1 minute for rebuttal. I want to begin by emphasizing that the system operators agree with and join all the arguments Mr. Shepard has raised about why the entire regime of study delay penalties is unlawful. But if this court rejects those arguments, then it must reach the additional problems raised by FERC's imposition of that regime on the system operators. And I'd like to focus.
One quick fact question.
Yes, Your Honor.
All system operators are nonprofit.
Yes,
I'm sure it's universal.
yes.
Okay.
I'd like to focus on one in particular, and that's whether FERC has adequately addressed the different ability of the system operators to pay the study delay penalties. And so here's the very brief setup. FERC admits, it said in the order, that the nonprofit system operators are materially different from the for-profit transmission owners in their ability to pay penalties, number one. Number two, FERC is not allowed to treat materially dissimilar entities similarly. And so, three, it purported to, and this is a quote, account for the differences with various supposed accommodations. Here's the problem. FERC's reasoning doesn't hold up. As FERC itself recognized, the way system operators differ from other transmission providers is that they lack a guaranteed means of absorbing the penalty costs. And so put another way, that means they lack access to financial resources to pay the penalties without first getting permission from FERC. And so the problem is every one of the purported solutions FERC provides isn't responsive to that problem. They all come back to ask us for permission. And so that's ultimately, in a nutshell, why the reasoning doesn't hold up. The solution doesn't actually address the acknowledged problem. So, and as Commissioner.
They recently acted, I think, on PJM. Well, first of all, they delayed the penalties for roughly 3 years, which is plenty of time for folks to file a 205, make a 205 filing. Can you explain, did they authorize, how did they address this issue or not in their action on PJMs?
This issue did not come up in the PJM filing. And the response, Your Honor, to the 3-year delay.
I'm sorry. What? I don't mean to, I want to hear your 3-year delay thing too, but why wouldn't PJM have asked for this authority?
I don't think they just haven't raised the issue yet. The PJM thing was about, one of the issues was whether they even have to comply with the new study regime.
Was it filed after the 2023 order?
Yes. So FERC rejected.
It was not to ask to pass this on to their customers.
That issue hasn't been raised yet. But one of the things that PJM said, for example, was that they were essentially wanted to continue to use the reasonable effort standard, and FERC said no. So there could be multiple other, this issue could come up later if you reject this challenge. But I think the problem.
Right.
Yes, Your Honor.
I want to let you answer. I just make sure I'm understanding what you're saying to me here when you say it could come up later.
There could be another 205 filing.
But they've had 2 years now and they haven't made a 205. Have any system operators since this order became effective made a 205 filing asking for the ability to pass on these penalty costs to customers or have some other avenue that they've proposed for dealing with that?
As I understand it, that request hasn't been made, but Your Honor, if I could answer the question to that, which is, I think it comes back to our point is they can't kick that issue down the road to a 205 filing. And the reason for that is that they have acknowledged that there is this material dissimilarity, and that question of discrimination has to be addressed in the order itself. So the FERC has cited to the Mobile Oil case, the Tennessee Gas case, and those cases do say that agencies don't have to solve all the problems in a particular rulemaking. But this court also said in the Maryland People's Council case from 1985, Judge Scalia opinion, that that may be true, except where the issue goes to the heart of the question that is before the agency at the time. And this question of non-discrimination goes to the heart, that injustice and unreasonableness, right? That is the burden that the agent, that is a very statutory authority question that is before the agency. When it goes through a 206 process, there's the two-step process from Amerimain. They have to, one, find that the existing rates and practices are unjust, unreasonable, or non-discriminatory. Then they have to put in place a replacement rate. And to do that, the agency must carry the burden of establishing that it's just, reasonable, and not discriminatory. And here they acknowledged that there is a right discriminatory concern before them at the time because they acknowledged that the system operators are different. They have to answer that in the order in order to have satisfied their requirement under 206 to promulgate a replacement rate. So my answer to your question, Your Honor, I mean, yes, there are practical questions about have the 205s been filed, what might they or might they not do with it? But the problem is they never resolved the question of non-discrimination that they themselves acknowledged was before them, and the statute requires them to answer that question.
Yeah, so my question wasn't to the exclusion of, I assume one could both litigate this claim as you are here, that it's discriminatory or unreasoned in its differential treatment, whichever label you want to put on it. And also belt and suspenders, make a 205 filing asking for an alternative means of dealing with these penalties. But maybe I've misheard. Are you saying a 205 order, they can't make a 205 order for system operators, to approve this payment system?
No, they can. I'm saying that is not an adequate answer to your point. There's the two, right? That is not an adequate answer for purposes of this order because it doesn't satisfy their burden under 206. At the time that they promulgate the rate or practice, which is this order, it doesn't satisfy their burden to show that the replacement rate is just, reasonable, and not discriminatory because they have acknowledged, right, that there is this material dissimilarity and the statute requires them to address that. Also to your Honor about the subsequent 205 filings, there's a couple different ways to address this pass-through penalty. One is to file a 205 in advance and ask for a default structure. And the other is when penalties are imposed, right, to then file a 205 with respect to each one of those penalties and ask for the ability to pass those through. I mean, as they point out, if there is a penalty imposed and there's an appeal process, as you were discussing with Mr. Shepard, perhaps the penalty would be lifted, right? And so there would be no reason for that particular penalty to ask for a 205. So if you decide that FERC can kick all of these non-discriminatory questions down the road to subsequent 205 filings, there will be opportunities for the system operators to address these pass-through penalties at those times. But
I would have assumed they'd rather have an upfront or answer and mechanism for dealing with these, assuming that there will be delays. Maybe there won't now because there are improvements, but rather than doing it after the penalties.
And they do, which is precisely the sort of practical basis, right, behind this argument, which is this dissimilarity exists today. We are on unequal footing today. The uncertainty is a real problem for us because it means that the penalty regime has a different impact on the system operators because they don't even know if a penalty is imposed and it's upheld, how they're going to pay for it. So yes, they do want the certainty, but the legal argument here, right, is that everybody agrees that unequal footing exists today.
That's what I want to. So imagine in the counterfactual that every system operator, when this rule came out, said they say we can deal with this through 205. All of them had filed. Every single one had filed a 205 petition asking to be able to pass through to customers, or maybe they come up with some other creative way of dealing with, but asking for a way for them to deal with it.
Sure.
It's reflective of their differential circumstances. And FERC grants every single one.
Yes, Your Honor.
Would you still be arguing that the rule is invalid because it's discriminatory, or would that show that the rule, which consists both of this penalty scheme and the special avenue for relief for system operators, which doesn't apply to anyone else, combined would show that in fact it's not discriminatory?
I understand the question now, Your Honor. I think the answer to that is twofold. One, the short answer is yes. I would still be arguing that, and I'll explain why. I think if in this counterfactual, the 205s have been filed for default structures, they have been passed, and I'm standing here today and said, practically it would resolve a lot of the concern, right? But it still doesn't change the fact that the statute required FERC at the time that it promulgated this rule to answer and resolve the question of non-discrimination. Because they can't.
Couldn't the answer be, we don't want to impose some sort of global way of dealing with penalties for system operators because they might have different ideas, and innovation is how things go forward. So instead of us saying, here's how you can deal with it, top down, we want to hear from you on what you think would be fair and everything under the circumstances way of dealing with this problem, bottom up.
I think it might be different if I could add one more piece to your hypothetical. And they said, and we will not put this penalty regime into place for system operators until that is decided, right? And I know your Honor, they said there's a 3-year delay, but there was no guarantee, right, that they would decide some sort of default structure if it had to be a different one for each system operator before the penalty regime went into place. That's what MISO asked for, right? They said one of their alternatives in the rehearing petitions was, hey, let's figure this stuff out ahead of time before the penalty regime goes into place. Then you will have answered the material dissimilarity that everybody agrees exists, and you will have carried your statutory burden to resolve the discrimination. I mean, Your Honor, I understand your counterfactual hypothetical, but I think the problem is it assumes that it's okay to kick this can down the road. I mean, it's always possible.
Kicking the can down the road, I think my question is, there were different ways of, FERC acknowledged the differential consequences here. So we don't have that situation where they just didn't, they acknowledged it. And they could have said, here's a cookie cutter answer of deal with it, charge them this way. And maybe you all would say, that's fine, that's reasonable, that's good, you dealt with the problem. Or they could say, you tell us, based on the characteristics of your own particular system, your own customers, how the whole thing's going, what works best for you.
Right.
We'll review it because we have to, that's our duty. And I thought I heard from your answer that the first would be okay under the law, but the second is not.
I think the second might be okay, maybe would be okay if they had then said, and let's go through that process before the penalty regime takes
I have
effect.
another fact question. This is a nerd fact when you're for nerd things. I have no idea. On average, how long, once a 205 petition is filed, does it take for FERC to act on it?
I don't know the answer to that question, Your Honor. I will admit to being less of a FERC nerd than my co-counsel. So I don't.
It turned out on average, it was 2 years. I don't mean to build any lilies here or anything, or disparage them if they're doing them super fast.
I understand, Your Honor, but I think
they allowed the time here and nobody's taken advantage.
I think the issue is all of your hypotheticals, I think, again, with respect, sort of assume that it's okay to resolve the non-discrimination question in the future. And then if it practically might work out, then we're okay, right? And the the contention that I have is it might have worked out and it might have not worked out, right? And under your hypotheticals, yes, it did work out in that hypothetical world. Everybody filed the 205s. FERC acted expeditiously, came up with solutions that resolved the discrimination. But the problem is that that's one hypothetical in the universe of hypotheticals that might have happened under this order. And so,
But we don't, it's all hypothetical because I'm actually quite astonished to hear that no one's asked in two plus years, 2 years, no one's asked. No system. I mean, the brief comes to us as this is why this is a huge problem for system operators, and it makes sense. And FERC acknowledged that they're just in a different place. And that's the theme of this problem on discrimination is what are we going to do with this bill when we get it? We can't do what everyone else can do. And FERC says, we hear you. Here's how we can deal with it. As part of the order, they didn't do this as some post hoc letter to everybody. As part of the order, they said, here's how we will prevent that discrimination. And no one takes them up on the offer.
With respect, Your Honor, what they say is, here's how we might prevent it, but we might not. So for example, they point to some other prior regimes that have penalties, like the NERC reliability regime, where there's a similar problem. And what's happened in that regime is that there are 205 filings that happen after the penalty is imposed. And in those cases, FERC has granted the ability to pass through. But with every single one of them, they say, let's all remember, this is case by case. And we're going to, if there's another penalty, we're going to look at that penalty. You're going to have to file another 205.
That's the problem with your after the penalties attached process, which it sounds like maybe people want to do. If they've offered you an upfront tariff amendment to allow you to deal with this, but going forward, you won't have to do it on a case by case basis.
But the reality is that they haven't said we're going to do this for you. They said, come to us. You can come to.
People have to come make their records. They can't license up front. They've chosen not to do a cookie cutter. Everyone can do it this way. You come tell us, but we can't approve it until we see what you're telling us. It might be that we would like to protect ourselves by charging 3 times any potential penalty in advance, the maximal penalty in advance, because we don't know what penalties will be. And they go, oh, well, that's too much.
Right.
They can't say we will allow X or Y without knowing what's presented to them. FERC all the time, FERC qualifies things by saying, here's a mechanism, we will review it. There's legal standards governing how we review it. This is not completely within their discretion. There's legal standards, there's legal review in the courts.
But the point of disagreement, I think, Your Honor, between me and you is that they said, you can come to us with these default filings. We might grant them, we might not. We're still going to put this penalty regime in place. They specifically rejected the request by MISO, one of the system operators, that you should hold off on the imposition of the penalty regime until, look, you want to invite us to file some stuff? Let's file some stuff. Let's work out what these default structures are before the penalty regime. And that is the.
They had rephrased it and said, we're going forward with this rule, but we have this avenue, special counter over here for system operators, that is part of our rule. And we are allowing you enough time to come to us. And we, imagine they had added this, will act on your 205 petitions within a time frame that should precede, assuming that everyone knows when a cluster study cycle is. Let's assume everyone knows it's 3 years. He said, and we will, if you file them, within the first 6 months or 8 months after the order, we will act on them within 3 years. Then you'd be fine.
I think
it would be this just another way of saying the penalty. Don't worry, the penalties won't kick in for you until we have acted on your application.
Yes, I mean, right. I think if we assume that's another way of saying that, I think if that's what then I think it would be materially different, because again, I think the obligation is on them to take the steps that will guarantee that this discriminatory problem that everybody agrees exists will be resolved. And what they did here is they reserved to themselves the unfettered discretion while still putting in place the penalty regime to maybe resolve it and maybe not resolve it. And Your Honor, I'm not going to assume things, but I think the dispute here might feel a little academic, but I don't think it is academic, because I think the issue is, it's one thing to have them say, whether it's through some creative process, as we've discussed, here is how we will resolve this, period, full stop, before the penalty regime goes into place. Again, that's what MISO asked for. And they specifically said in the record, we are rejecting that. We are rejecting the idea that this penalty regime cannot go into place until, I can, Your Honor, if you would like, I can, this page, JA 3736, paragraph 405. They say, we decline this invitation, right, to guarantee essentially that we're going to come up with some structures before the penalty regime goes into place. And Your Honor, that might be a question for my friend at FERC. Why reject that? And I think that's why it's not an academic difference. FERC resisted that idea.
Did any system operators complain in the record, put in a comment, an objection on rehearing that said 3 cluster study cycles is not enough time for us to get a 205 filing into you to deal with these penalties? Did they tell FERC that's not, if FERC was thinking, I don't know what they're thinking, but they were thinking in their head, like I've been saying, and I don't know. But if they phrased this in a way to allow enough time. Did anyone say that?
I can't remember that, Your Honor. I can't remember specifically.
Okay.
But I think I would just suggest that the MISO suggestion that you should hold this off is of the same type.
I'm not, no, hold off then is just don't do it until we all get together and we all solve this thing. And that puts an awful lot of control in the system operators over the time frame. And
Not necessarily, because
not necessarily, but maybe.
Well, because I think under 206, right, they could require us to file. They could say, submit something within 150 days or write your proposals within 6 months. I mean, FERC has
stopped your clients from doing that too.
I'm sorry.
I mean, it's just nothing stopped your clients from doing it. I mean, it's like if we're court and we're like, you know, we set briefing schedules, we want cases to move. And if the parties go, it's a complex case. Let's figure out exactly who's briefing what and who's doing whatever. And don't set a briefing schedule till we get back to you on exactly how we want it all to shake out. I'll let you know. And the other side objects, by the way.
Right. And Your Honor,
we go, we're not going to give you total control. Make a suggestion, but this is a multi-party process here.
Yes, but ultimately in that situation, right, I mean, the court has the final say, and I think FERC here could have required us to do it. And the key here, and it comes back to the legal point that I was making, is that the burden is on FERC under 206, right? It has to carry its burden of showing that the replacement rate it's promulgating is just, reasonable, and not unduly discriminatory. They had the means within their power to get that done. And so I don't think this is an academic debate. I think we do understand each other about, right, what needed to get done. And I think, you know, our contention is that FERC didn't carry its burden. It tried to put it on us, and ultimately it could have done more.
All right.
It's great. Very helpful. There's something in the briefing about how some system operators need their stakeholders' approval.
Yes, Your Honor.
File a 205, make a 205 filing.
Yes, Your Honor. It was NISO, the New York Independent System Operators.
And if I understand the argument, it's that some of the stakeholders are the customers who, under the 205 filing, will have to foot the bill.
Correct,
for
Your Honor.
penalties.
Correct, Your Honor.
So if those customers have a veto power over the 205 filing, and if they have a monetary incentive for that filing not to happen, then the filing will never happen.
Yes, Your Honor. That is an additional, I think, wrinkle to the difficulty. It highlights, I think, the dissimilarity between the system operators and.
I mean, in your answers to Judge Millett, you did seem kind of bullish on 205 filings being the solution. You faulted FERC for not kind of guaranteeing them as the solution, but I don't understand.
I appreciate your point.
So bullish on 205 filings if they're not going to happen for some system operators.
I appreciate you reminding me of this wrinkle that NISO has. I mean, speaking for all the system operators, I think there's a view that, potentially we could essentially work this out with FERC. But yes, I think NISO has a very unique, each of the system operators actually has, they have their own agreements with their transmission members in terms of, how they work. And this court recognized in the Atlantic City case that 205s with respect to ISOs and RTOs are a little bit different for than transmission owners for this very reason.
Maybe a counter argument to your argument, your NISO specific argument is, look, that stakeholder probably doesn't want to pay the penalty fee, but they'd rather pay the penalty fee than have the system operator go bankrupt. So they actually will allow the 205 filing?
Potentially. FERC did not respond to this problem that we raised in the record. So again, I think it comes. Yes, Your Honor.
No, you can finish something.
No, I was just going to reiterate my point.
Okay. Did Mr. Shepherd say anything you disagree with?
I don't think so, Your Honor.
That's helpful too. And then one of the things that Mr. Shepherd and I were talking about is the at least theoretical possibility that whatever increased costs there are to transmission providers to do these studies faster, those costs could be passed along through rates to the consumers. Would that also, would that be as theoretically possible for the system operators as it is for the load serving entities?
So I don't want to, I think the answer is complicated because each of the system operators has their own tariffs and their own sort of essentially contracts with their transmission members and how operational costs are passed through. I think the main point here, not to duck your question, is on the penalty. There's nothing that suggests that they can recover that from anybody. And I don't think FERC disagrees with that.
And then I guess my last question is, there was this joint unopposed joint motion about argument and what was going to be covered and not covered. And what am I to make of the motion basically saying that you all didn't want to talk about the energy, what's the name of that thing?
Oh, the energy service standard versus the
argument.
No, it's not that we don't want, I think we were trying to conserve the court's time. And so we thought the main arguments to advance were essentially 1, 2, and 4, and 1, 2, and 3. And we said for issues 4 and 5 that we're happy to rest on the briefs, but we are available to answer questions if the court has any. And I am available to answer questions on 5, which has to do with the energy service standard versus the network service.
Can I just see if I understand the energy
Please.
service standard?
Of course.
Imagine I am an interconnection customer and I go to transmission system A and I say, okay, I want to connect and you need to do a study. And it turns out that when I connect to system A, that's going to have some kind of effect on system B. So system B, there needs to be a study about system B. I tell system A, I'm looking for I'm looking for energy service.
So non-firm service.
Non-firm service.
Okay.
System B says, well, when we do this study, we want to do a study based on firm service.
Okay.
Is that the status quo before Order 2023? Have I described it?
I don't know if maybe, I think the status quo is that the affected system has the flexibility to justify whether it wants to use a network service or an energy service. But maybe the better answer to your question is that that's not the factual scenario that is of concern here and why there is an objection under issue 5. So the factual scenario that's of concern is generation interconnection customer goes to transmission system A and says, I want firm service, network service, but it's going to have an impact on system B. FERC has now prohibited System B from using a network service standard to figure out what the impacts on its system are going to be. Now, FERC's answer to that is, in the ordinary course, essentially the affected system is going to have two opportunities to figure out what the impacts are. There's going to be the initial modeling or study that's done at the time of the interconnection request. And then they say, but that's different from the ultimate transmission when System A will agree to interconnection, and then there will have to be a subsequent request by the generation customer, and System A at that time will then decide whether there actually can be transmission, whether power can flow. And then at that time, System B will have essentially another bite at the apple, right, to figure out whether there are reliability impacts. Because FERC agrees that the energy service standard, because it's less rigorous, isn't going to catch the same number of reliability problems as the network service standard is. And the objection to issue 5 is that's not always the case. There's not always going to be two opportunities because, as an example, MISO, when it allows interconnection to happen, also grants the transmission service, the deliverability, essentially. And so SPP, which is a neighboring RTO, doesn't get the two opportunities to assess reliability. And so they say, so for that reason, we want the flexibility to continue to use the network service standard when the request is for network service, because we're concerned that the energy service standard is not rigorous enough in that one opportunity to catch all the reliability concerns. And so the argument in issue 5 is that FERC does, again, similar to what we were talking about before, FERC sort of acknowledges this problem, says that, but SPP hasn't shown that it occurs outside of its particular circumstances and that you should file the 205, resolve it. Now, our response to that is that that 205 opportunity is illusory because they've already said having the flexibility to decide between energy service and network service testing is unjust, unreasonable, and discriminatory. And they say, well, look, in the 205, we'll give you flexibility. But the reality is, yes, there is flexibility, but not flexibility that is at odds, directly at odds with what they have already found is unreasonable in the order. And Judge Millett, you mentioned the PJM compliance filing. I think that's a very good example. We've already seen this in play. PJM in its compliance filing said, you know what, we kind of want to, essentially, this is the way FERC characterizes, we kind of want to continue to use the reasonable effort standard and not the, the deadlines with the cutoffs. And in rejecting that, FERC says, no, that is a collateral attack on this order, right? And that's our point here, is that the idea that we can come back with a 205 and ask for something that is directly contrary to the fundamental holding that forms the premise of your order, that is an illusory answer to, again, a problem that is acknowledged.
Okay, so I think I did follow, and I think largely persuaded about especially your last few points. I'm not sure yet, though, that the system that 2023 creates is worse than the system it replaced. And here's why. Either the system B is going to, in my hypothetical, either the system B is going to have the flexibility to decide what kind of testing to do, or it's going to not have the flexibility. When it has the flexibility, it's going to choose to test the firm service, because that's going to be a higher number, higher dollar figure. And that's an accurate figure if it turns out that the service ends up being firm service. And it's an inflated figure if it turns out that the service ends up being non-firm service. So sometimes it's accurate and sometimes it's inflated in favor of system B.
So I understand, can I answer your question? Because I think I understand it. So I think the way to think about this is to remember that the 206 process is 2 steps, right? So first, FERC decides that the existing rate or practice is unjust, unreasonable, and discriminatory. And perhaps I think that goes to your question is like, is the original system, is the current system not good?
Right? Maybe so.
Maybe so. Maybe so under step one. Our objection is with step two, I think, is with, so what are you promulgating in its place, right? And what they're promulgating in its place is everybody has to use energy service. And, there's a middle ground there, which is you have to use energy service unless maybe the request is for network service, right? Because it gets at your hypothetical, which is, well, what happens if the generation customer is asking for energy service, but you really want to use network service standard? There are other ways to skin the cat, so to speak. And I think our complaint is that what they promulgated at step two hasn't adequately addressed this problem.
Is that proposal in the record? The proposal you just made, what you should do is let them use, it's hard with cluster studies because you're gonna have a bunch of clients and maybe nobody but one wants firm service. I'm not quite sure how it works out, but was it proposed and all this was explained how it's gonna work for cluster studies?
I believe so. I think the SPP's request is that they want to be able to use network service where the request is for firm service.
I thought the argument there was the way they've designed their entire system up front is this network-driven characteristic. And they're their only one. And so the question here is whether
No, I don't.
got to sort of wag the dog here.
I see what you're saying. No, I don't think that that's right. I think they do.
So they propose, let us
do network
and
service.
let the people have let the customers have the choice as to which they want. If the customer wants network service, let's use that. If the customer wants energy
service. Yeah, I think.
Makes no sense. I'm sorry. It's all energy service.
I think.
If they want champagne, we'll calculate champagne. If they want sparkling water, we'll calculate sparkling water.
I think in the yeah, I don't know that I would put it as let the customer choose, but I think it would be where the interconnection customer has asked for network service, because that will have higher reliability impacts. We should be allowed to do an effective system study using network service as well, and not be limited.
And they've made that precise proposal to FERC.
I believe so, but I will check.
If you could.
If I'm incorrect about that, I will let you know.
Okay. Any questions? All right, thank you so much.
Thank you, Your Honors.
Appreciate that. And are you doing rebuttal? You're both doing rebuttal?
I have just 1 minute, yes.
All right, just want to make sure. All right, we'll hear from the, somebody. Good morning.
Morning. May it please the court, Melissa Alfano for the Trade Association petitioners, or as Mr. Shepard said earlier, the other people protesting the rest of the rule. I just want to note, we're not protesting or arguing against the rest of the rule. And in fact, we're interveners on behalf of FERC in some portions of it. We're here today to address two limited issues where FERC, without explanation, declined to allow penalty-free withdrawal when interconnection customers are facing substantial and unexpected increases in interconnection costs. And in fact,
I thought they did explain it, and we're disallowing it at this very late stage because your withdrawal is extraordinarily disruptive to both the transmission providers and everyone else in your cluster. And so there's going to be whole new costs and delays lobbed onto everybody. And we got to make a decision about who bears the consequence of that. And it's going to be the one who withdraws rather than everyone else in the cluster and the transmission provider. You said there's no explanation. I think that's an explanation.
Well, that would be an explanation had it not conflicted with paragraph 43 of the order, in which FERC said cost uncertainty poses a significant barrier to interconnection because it forces interconnection customers to finance substantial increases in unexpected costs. What FERC is effectively doing is at this very late stage in the process where interconnection customers are receiving one of their final studies, or in the case of affected systems studies, receiving the final study after it even executed the interconnection agreement. What FERC is doing is saying, despite the fact that your costs nearly doubled in some instances, or in the case of affected systems, it could have doubled or tripled. And by the way, as a couple of commenters pointed out in the underlying proceeding, these are not small amounts of money. These are, millions, sometimes hundreds of millions,
Under the old system.
under the old system.
Right. Well, the whole point is the current system is with cluster studies and everything is supposed to reduce surprise. There will still be some, but it should hopefully be less. Is that wrong? Did I misunderstand something?
It should hopefully be less, but there's no guarantee. And yes, FERC has moved to cluster studies, but has been pointed out earlier, many of the regions have actually already moved to cluster studies before Order 2023. And so.
How long before?
I can tell you for a fact in MISO, it was, I think, like 2016. I think other regions were slightly after that. MISO was a bit of the innovator there. But it was still the case that there were these unexpected costs and affected systems. These studies have played the process for quite some time, not doing the studies themselves, but the fact that these studies come in late and come in with substantial increases in interconnection costs. So to your question about, I just want to make sure I was saying it right, that the interconnection customers would be paying, sorry.
So what I was saying is that, look, if a surprise happens very, very late in the process, there's going to be pain all around. And what FERC decided is, well, who's going to bear that pain? And you don't bear all the pain. It's a 20% penalty. It's not 100% penalty for the costs of your withdrawal, or for the costs of the 20% of the, I guess, the increased costs that go on to everyone else. And so FERC had to choose somebody. You want them to choose the withdrawing person still gets out of having to pay anything, which means everyone else around them has to absorb it. Is that right?
That is right. But the everyone else absorbing it is absorbing far less than the withdrawing party is.
Well, it's spread out across more people.
Yes.
Well, your clients are going to be a lot of those other people who have to absorb costs, probably as often as they're the one, or maybe more often than they're the one withdrawing.
They are.
Going to be the people in the cluster.
Yes, but the harm to those customers is far lower than the harm to the withdrawing customer, who would have to pay 20% of the new network upgrade costs, which can be in the millions of dollars at that point. Or, and especially since in terms of affected systems, without any sort of cap, we don't know if those cap costs could be double or triple the original estimated network upgrade costs. So FERC did this all in contradiction to what was going on. And I just want to point out, we don't dispute the concept of penalties or even graduated penalties, but what FERC is doing in its Order 2023 and its brief is justifying the graduated penalties of the penalty structure. We didn't protest that there. What we are saying is FERC failed to give a reasoned explanation as to why that 100% threshold, limited instances where interconnection customers are at the last minute faced with costs that render their projects uneconomic, why that threshold is appropriate. And so what FERC then does in its brief is rely on two cases, Public Service Colorado and PacifiCorp. I want to note that these two cases didn't actually appear in Order 2023 to support the 100% threshold. In the NOPR, notice of proposed rulemaking, it was for the penalty structure generally, and then in the order, it was for two different pieces. So FERC relies on these cases in its brief now. But what FERC is really doing now is engaging in a post hoc salvage operation for its failure to actually explain that 100% increase.
100%. So, if it's less than 100% surprise, it's going to be less money, less pain. I mean, you talked about great big millions and millions of dollars surprises. I have no idea how these numbers work out, but won't a lot of those be, especially if you bring in the affected systems numbers, get you to the 100% threshold or not?
It could bring in the affected systems threshold could. But what FERC also declined to do with respect to affected systems studies is require them to come in on time. There's no guarantee that those projects can come in on time, and there's no cap on those costs. And FERC, in fact, admits this in Order 2023A, that
We're
they,
talking about, this is the other thing that's really confusing me in this case. Are we talking about jurisdictional affected systems or non-jurisdictional affected systems?
well, in some cases, it is non-jurisdictional affected
Do you have a
systems.
sense of how, I really don't, because it's important, I think,
Right.
to understand this argument. Is there a percentage of the affected systems out there? How often it is the affected system is jurisdictional versus non-jurisdictional?
In case of the significant increase or just generally?
In case of where you're concerned, the sticker shock ones, as FERC calls them, oh, it might be more than sticker shock. It might be like bowl you over prices.
I don't have that number, but we could.
Do you have an experiential estimate or sense? Yes.
From the developer perspective.
Yes.
Um,
Yeah, you guys have been blown out of water by these prices, I guess, in the past. You have clients who represent a lot of these folks. How often pre this order has it been a huge problem when it's a non-jurisdictional versus jurisdictional?
it's been a problem in both, to be quite honest, and interconnection customers tend to keep their project economics in terms of what sends them out of business and out of the queue because their project has been completely upended.
Because there are other protections in the order when it's a jurisdictional system that allow you to postpone doing your large generator interconnection agreement if the assisted system study is delayed coming in. You have until 30 calendar days after receipt of the affected system study report to execute your large connector interconnection agreement. And it's that execution of that agreement that takes you out of the 100% threshold. So as for jurisdictional affected studies, you actually have protections here that allow you to not take yourselves out of the 100% threshold until after you receive the study.
Correct.
You haven't challenged that. Okay, so are we only talking now about non-jurisdictional affected systems?
We can be, yes. And what that actually just highlights is there's a
We don't know how
limit.
many of those are, how often that is.
But exactly, we don't know how often there is. And
We don't know how much of it's a problem. I mean, if a lot of us, I'm only asking out of my ignorance, if a lot of the affected system study delays are coming from, and I just don't know, but if let's assume, for this question, 70% are jurisdictional. FERC has given you all the tools you need to protect yourself from getting thrown out into no withdrawal penalty avoidance, no 100% avoidance at all. You've got that. So it'd only be like 30%.
yes,
But if it's reversed, if it's 70% are outside jurisdiction, then it looks like a different problem. And so I just didn't see anything in the briefing, but tell me if there's anything that I missed in the briefing or in the record that tells me how big the non-jurisdictional problem is where FERC just can't do anything to kind of help you out because they're non-jurisdictional.
we don't have that number. Or
Does
at
it
least,
matter to show whether this is unreasoned? Because we could play number games all morning on this. If it was, less often it's non-jurisdictional, and they tend not to have the biggest sticker shocks. It's jurisdictional ones that have the biggest sticker shock. That's one way. If it's mostly non-jurisdictional, and those are the ones that come in with the explosively high surprises, that's a different problem. But if FERC just wasn't told anything about, they did what they could to regulate for the affected systems that are jurisdictional. So I just don't even have a sense of what the scope of the problem is here.
so what FERC failed to do was set any threshold. Both, they have some protections for if the affected system is jurisdictional, but then none really if the affected system is non-jurisdictional. So
So we're really only talking about the failure to set a threshold for non-jurisdictional, because the protections they gave you allow you to keep yourself in, still subject to the 100% withdrawal exemption.
Yes.
You could just, and maybe you don't want to, maybe you want to sign some papers earlier, but the clients actually get to control that. So that seems hard to understand how that's much of a problem. Or it hasn't been briefed from the perspective of we have complete control, or we have control over this process when it's an jurisdictional affected system. So we're only, I'm assuming, unless I'm wrong here, but what you're really concerned about is the lack of an exemption, any exemption for non-jurisdictional affected systems, price surprises at the very latest stage of the interconnection study process.
That is one of the concerns. And looking at it this way, there are far fewer non-jurisdictional entities that this is going to come up with. And that actually highlights the need for the exemptions in the first place. This isn't something that's going to have a massive and often impact on the customers in the queue, which again, that harm is spread amongst all of the customers in the queue that are remaining, as opposed to one customer incurring a significant harm.
But that's the one that's causing the problem.
Is it? The customer has done everything at that point, paid the increased
It's choosing to
deposits.
withdraw.
It's not choosing to withdraw, it's being forced to withdraw.
Well, it's came into, again, with the rule on the book, I'm not an economist. I'm assuming an economist can calculate all these risks and out to you. And so you will have made a sophisticated decision about going into this. And one of those things will be factored in is you can figure out, first of all, in advance, if there's a non-jurisdictional affected system anywhere along your line. You can figure that out in advance. And then they can come in. And by the way, they're not going to come in now with the champagne service, right? So they're going to come in with the cheaper version service anyhow, I think, or maybe not. Maybe, I guess FERC can't even dictate what modeling they use. Maybe I'm wrong about that. But you're going to know up front if you've got an unregulated effective system. And so it's just a question of, what companies do all the time. And that is calculate economic risks and pros and cons, benefits and not, what are the chances, and then make sophisticated decisions.
They're not going to know for certain upfront what these customers are doing. What they have to do in the interconnection process is make decisions based on the best information available to them. And on the energy service modeling, we're not taking a position necessarily on whether or not it should be the case, but there's a paper in the record, the NL paper. I can give you the JA site somewhere. But there's an NL paper that basically explains that there is no protection that would ensure that these costs are limited, or that even these costs were identified in the earlier stage of the process. Because when you're going all in on cluster studies, which is fine, we never protested that, but you don't quite know your impacts or your costs until you know your cluster. And that is something as you move forward. So these are projects that give estimate or take estimates, think about what are the possibilities, and then make the investment based on that information. And so what we are talking about are these late stage costs that are unexpected, because despite everything that those projects have done, all of the due diligence, all of the increased deposits, all of the increased site control, despite all of that, their costs can nearly go up. And that's the limited situation that we're talking about.
I think this rule has been in effect for a couple of years now. Do you have an example? I know it's outside the record. I'm just, you guys know this world so much better than I do. Of a non-jurisdictional affected system blowing everything up.
So despite the rule being in effect as a rule, it actually hasn't been implemented. And it was just earlier this summer where FERC accepted the last of the major RTO's compliance filings. So it's still going into effect in a sense. And we haven't gotten to the actual rubber meets the road. There is a case though, and it's cited, I think, definitely throughout the proceedings. The Tenaska case, Tenaska Clear Creek versus.
That was pre-order.
Yeah, that was pre-order.
Yeah, I think I'm not sure that's helpful or not, but tell me what the number was in that case.
There were several numbers in that case, and it started around 100 million, and at some point went up to 900 million. And so part of the fight was
And that was a non-jurisdictional system.
Correct, AECI.
But your costs, maybe I'm wrong here, will the costs still be spread around, if you stay in, won't the costs be spread around everyone in the cluster, or am I wrong about that?
Well, if you stay in, the cost of the upgrades are allocated to you based on how much, it depends on each region. However, if you stay in, you have to be stuck with, this is the penalty-free withdrawal depends on the cost that you incur. The cost that you may shift to other interconnections if there is a withdrawal is not necessarily the same number, because it depends on who is in the cluster, where they are located, and what what other network upgrades might be identified in a different manner now that one project is gone. And it's difficult to see in a cluster study. Excel points out in their comments that it's hard to actually know what the impact will be on withdrawal until the withdrawal happens.
All right, I don't think there's any further questions from my colleagues. Did you have a point or two that we didn't? I didn't. I shouldn't say we. It's my fault. You didn't get a chance to make that you could make quickly?
Just a real quick note, since we were talking about the rule not quite being in effect, but not really being in effect. This is a situation where, I do want to note we asked for remand without vacatur, just because FERC has now accepted all these filings and parts of it will be going into effect. What we are pointing out are things that are occurring at the very final stages of the interconnection process. So we are years away from this. So this is something that FERC could, on remand, come to a different conclusion and then fix the error, and then it would still not actually cause the full harm until later, or prevent the harm, I guess. All right. Thank you.
Now we will hear from FERC, who's been talked about a lot.
Thank you, Your Honors. Good morning, and may it please the court, Robert Solomon for the commission. There is much legally that I disagree with, especially as to the transmission providers, but I think I will start, if you allow me factually, to correct two misstatements. One, Judge Walker, you were asking Mr. Shepard about the recovery of study costs if they turn out to be loftier and more prohibitive than anticipated. There is a true-up in the rulemaking. There is a true-up in the tariff. In particular, Section 13.3 of the interconnection procedures, which you can find on 4058. The commission also explained this on 3713 and note 702, identifying relevant tariff provisions. There is a true-up. I think the anticipation is that the study costs will be less than the initial study deposit. But if in fact it becomes wildly expensive to hire qualified electrical engineers, if it turns out that the study costs are higher than the initial study deposit, then in fact there is a true-up, and interconnection customers will pay the increased study costs. There was some confusion as to interconnection customers versus ultimate consumers or ultimate customers. But I'm glad you brought up, and I'm glad you focused on the interest of the ultimate consumer, because fundamentally, this is what the rulemaking is about. There is plenty of discussion of transmission providers and interconnection customers. The commission believes that we have appropriately balanced the interests of those two groups. But fundamentally, customers will benefit from increased competition in wholesale power markets with the effect of reducing wholesale prices and improving the reliability of service. That's fundamentally, that's our paramount concern. The other factual misstatement is,
Before you change it from the true up topic, can you tell me a little bit more about how that would work? So the transmission provider has to invest a huge amount of money in order to go faster than they currently go and meet these deadlines going forward. And they invest all that money and they're not fully compensated for that investment by the current costs of the studies that they charge interconnection customers. And so then are you saying that the way a true up would work is they would then say, well, we now need to charge a lot more for these studies, and would FERC have to approve that, or how would that work?
I don't think so. There is a billing and invoicing section of the tariff as well. And the process works as either a rebate or a surcharge that is the responsibility of the interconnection customer.
So presumably they would say, oh, we now need X more dollars from the interconnection customer for having done this study. You owe us X dollars. And I guess if the interconnection customer thought that was unreasonable, maybe they could go to FERC to challenge it or something. Is that right?
That is absolutely correct. There is always that opportunity to make a challenge at the commission to argue individualized circumstances. I think at the very outset of the argument, Judge Millett, you mentioned the ample process that is in place. Most of the focus has been on the possibility of making an individualized Section 205 filing, demonstrating individual circumstances or regional differences. I also want to focus on the compliance proceedings, which the commission has been considering for the last year, especially as to system operators, to the extent the individualized transmission provider believes that the default mechanisms in place do not appropriately fit the particularized circumstances of that particular transmission provider. The commission will review the compliance filing and determine if the transmission provider has offered a reasonable independent entity variation, if it's a system operator, or consistent with or superior to if it's a non-system operator. The commission does not want to be disruptive to the efforts that transmission providers have already made. And we are extremely grateful that transmission providers have taken the effort over the years to make filings with the commission and to try to adopt incremental improvements over the status quo. But fundamentally, what the commission has done here is find that the existing procedures, the existing rules, which may have been fine in the day, no longer meet the moment because of the changing circumstances of generators that wish to go online because of soaring electrical demand. We know about artificial intelligence and data centers. The commission identified a real problem that generators are unable to process through the interconnection queue and to go online in a timely manner. The situation was bad and the situation is getting worse. And
So
indeed,
even if we agree with you with respect to the problem, because nobody I don't think disagrees that there's an extreme backlog queue and all of that, there seems to be a lot of emphasis on the 100% penalty, and you're basing that on a case, you're basing it on comments, but is there any real empirical data about how you come to that number specifically, or are those cases and comments context specific?
Thank you, Judge Childs. There is empirical data and there are cases. The commission could have moved sooner. The commission adopted an additional rulemaking 5 years earlier in 2018. This was our Order 845 rulemaking. There were commenters who argued that the reasonable effort standard was no longer working and that the commission should impose deadlines. And what the commission said is that may be true, but we prefer to have additional empirical data. And the commission requested that transmission providers post and file information about the study process. The commission has identified.
At the number, like why not 75%? Why not 90%?
Well, thank you. This is the second factual misstatement that I wish to clear up. The interconnection customers, the clean energy petitioners, are arguing that the 100% figure comes out of thin air. The notice of proposed rulemaking itself at page 180 and note 209, when the commission proposed the 25% standard, the 100% standard, the no additional standard for affected system studies, the commission recognized that other transmission providers had previously filed with the commission, and the commission had approved withdrawal penalties. In particular, we cited Tri-State and Pacific Corp and Public Service Company of Colorado. Fundamentally, and this is what Judge Millett, you were bringing up, late stage withdrawals are particularly destructive. They are particularly upsetting as to timeliness and cost certainty. And what the commission did in this rulemaking, after reviewing the empirical evidence that we asked for, after reviewing the transmission provider filings that we had approved, we were able to take advantage of the early adapters in part. We were able to take advantage of the best practices in developing the rule and providing all of the particularized criteria. But we found fundamentally that there are two principal drivers of the delay. One, upfront, too many duplicative and speculative applications flooding the queue. So we adopted various standards, not just simply the withdrawal penalties, but we adopted substantially increased study deposits. We require interconnection customers to demonstrate site control and to demonstrate commercial readiness. And we believe we have made the job of the transmission providers much easier.
I'm still trying to get to your answer about the 100% versus the 90% versus the 75%, the number, not the problem, the number for the penalty.
Excuse me, Your Honor. The commission acknowledged that those cases that I had cited, those transmission providers specifically had asked for a 25% safe harbor penalty-free withdrawal at the cluster stage. Those transmission providers had specifically asked for a 100% penalty-free withdrawal at the facilities study stage. And those particular transmission providers had not provided for an additional safe harbor for affected systems for the reasons that Judge Millett had recognized, that the later the stage of the withdrawal, the more devastating the impact is on other interconnection
So is
customers.
this number going to be for everybody, or are you going to look at it on a case-by-case basis?
That is the number for everybody, but we don't think it's going to be a problem.
And the reason I ask that is because you just made a statement that says these transmission providers asked for. So it sounded like you were going case context specific.
Well, we needed something. This is a matter of line drawing, and even the clean energy petitioners agree that something more than 25% is appropriate for a late stage withdrawal. We could have picked 50, we could have picked 100, we could have picked 200. We believe there is plenty of authority for the proposition that something higher than 25% is appropriate. I think even clean energy petitioners agree that a higher number is appropriate at a later stage.
I'm guessing that like 10,000% would have been inappropriate. So why is the range you just described 50% to 200%? Why is that appropriate and 10,000% not appropriate?
Because we actually had those numbers in play with respect to transmission providers that had earlier made filings with us. And frankly, we're not.
Sorry, so you had at least two transmission providers that had adopted this very scheme that the commission had previously approved and had a chance to see it work.
Yes, which is.
But that was the empirical evidence you had.
I think that is empirical. I was focusing primarily on the additional data that we.
My question was a friendly question.
Yes, we feel like that is a very valid basis for picking a number. We have to pick a higher number, and it's a valid basis to pick the numbers that have previously worked. I also want to emphasize, Judge Millett, which you were emphasizing, that we believe that any unanticipated cost increase at the affected system study stage will come in when we're still at the 25 and 100% thresholds, because they typically will come in before the final cluster restudy or before the final facilities study. Judge Millett,
Are you talking about, oh, please go ahead.
Oh, I was going to say.
You're about to answer the question I'm about to ask, so go ahead.
You're correct that the non-jurisdictional providers are particularly problematic because they do not have the incentive that jurisdictional providers have. But where there is no penalty-free withdrawal, the commission is acting on behalf of all interconnection customers. Yes, there is the possibility that a single interconnection customer may wish to withdraw penalty-free from the queue at a late stage, but that will be at the expense of all other interconnection customers, including Ms. Alfano's clients, who remain in the queue and who will be subject to additional delay from further restudy and will be subject to additional cost. And particularly striking, I do want to point out that the interconnection customers in their brief, they never mention what we believe is the most important safeguard, which is there's never an obligation to pay a withdrawal penalty if the withdrawal will not result in a material effect, either as to timing or costs, on other interconnection customers that remain in the queue. Almost
That never happened?
no, we're not aware of that ever happening.
Right, so it doesn't seem like much protection. Of course, you just said by its very nature and timing, it's going to really be rough on everybody else, rough financially on everybody and time-wise on everybody else. So that test will never be met.
Well, it will be financially rough on everybody else inside the queue. All I'm saying is all of this discussion about penalty-free withdrawals, whether they should be 25% or 100% or 200% or 1,000%, none of that matters if there is no material impact on other interconnection customers within the queue. By definition, if the penalty-free withdrawals come into play, the safeguards that the interconnection customers are concerned about, by definition, there will be harm to other interconnection customers. That is the agency's principal concern, that the later the stage of withdrawal, the more destructive to the cause that we're all championing here, which is timely studies, a timely, transparent, cost-effective, and reliable interconnection process.
Do you have an answer to my question about how often affected systems are jurisdictional versus non-jurisdictional?
I think the percentage number is small. We're talking primarily, I don't know what the
Percentage
numbers.
of non-jurisdictional is small or jurisdictional is small?
Well, it's not just jurisdictional versus non-jurisdictional. It's non-jurisdictional that has not accepted as a matter of reciprocity the same open access, non-discriminatory transmission and interconnection service that jurisdictional providers have committed to. There is a process in our regulation.
So just to make clear, so there's a lot of non-jurisdictional systems out there that essentially will voluntarily sign on to the same rules as this order?
That is correct, because they also get the advantages of non-discriminatory open access transmission tariff.
And for those ones that voluntarily sign on, then the protections such as the host provider has to give you until 30 days after the affected system study comes in before requiring you to sign the large generator interconnection agreement, which is what takes you out of the penalty-free zone, will apply even to most non-jurisdictional affected systems.
Yes, Your Honor. I'm not sure about the exact percentage. The concern is lack of timeliness, and jurisdictional providers and non-jurisdictional providers who have accepted a reciprocal obligation so that they can receive the reciprocal benefits remain subject to the timeliness requirements, and affected system studies, the impacts on system B in Judge Walker's hypothetical, those are still subject to the 150-day timeframe. They are still subject to the $1,000, $2,000, $2,500 a business day penalty. So we don't think it's going to be much of a problem.
Did affected systems have to re-up under Order 2023 and say, yeah, we're still on non-jurisdictional ones, still have to say we're on board, or they already signed their agreement? I just didn't know if you've gotten a bunch of these reciprocity agreements in.
No, I don't think they need to re-up. They would need to affirmatively come back to the commission and say they no longer wish to be reciprocal.
Has that happened post-Order 2023 that you're aware of?
I am not aware of that happening since Order 888 back in 1996, our original open access transmission rulemaking. And I'm glad we have segued to that point, because what the commission is doing here is really nothing particularly different than the rulemakings that it undertook back in 1996 with respect to our open access non-discriminatory transmission rulemaking that was affirmed by this court in Transmission Access Policy Study Group and ultimately affirmed by the Supreme Court. This is really no different than our original interconnection rulemaking Order 2003, which was affirmed by this court in the 2007 National Association case. This is really a little different than the Order 1000 transmission planning and cost allocation rulemaking that was affirmed by this court in the South Carolina Public Service Authority case. Fundamentally, and Judge Childs in particular, you were asking questions about the statutory and constitutional underpinnings of our actions here, lest we forget, the commission has already acted generically. If anything, this is an easier case than those other rulemaking proceedings. But statutorily, under Section 206 of the Federal Power Act, what those cases instruct is that if the commission finds a systemic nationwide problem, the commission can act generically. Now, some transmission providers have made some filings with the commission offering incremental benefits, and the commission is appreciative of that. But of course, no transmission provider has offered the entire bundle of reforms that the agency believes is appropriate. And what this court has said in those cases is the mere fact that there might be pockets or islands of compliance does not mean that the agency was not able to act generically. And here we have the quintessential circumstances for an agency to act generically. One we already have. We have found that the old generic proceedings no longer work. We do have empirical evidence. In particular, we asked the transmission providers to give us data about their processing of the studies. And we found that despite best efforts, this still remains a problem. Indeed, the commission called it a dire problem of non-compliance uniformly across the country, including areas in which cluster study approaches have been in place for a number of years. The commission attached a very useful Appendix B to its Order 2023 that is found at page 2587. The commission also explained in considerable detail, provided all of the metrics of delay. We believe that this is a much more serious issue than the transmission providers let on. Yes, Your Honor.
On the topic of whether the late fees are a civil penalty or not, transmission providers argue that the fees are serve a purpose of deterrence, and your brief argues that they serve a purpose of an incentive. And I don't understand the difference.
We believe the commission has offered a performance incentive.
But that sounds like a deterrent against underperforming.
Well, transmission providers are claiming that we're engaging in Orwellian distinctions. The key distinction is the compensatory versus punitive description. That is the takeaway of the Kokesh case. And we believe that your hypothetical to transmission providers is very apt here. If the commission had said simply return all of the under recovery or the losses that the interconnection customers have incurred, that would be a classic compensatory remedy. This is nothing at all like the Kokesh case.
Do you agree with them that that hypothetical would involve much smaller fees than the schedule of fees here?
Not necessarily. It depends upon the degree of the losses of the interconnection customer. It depends how you define that. I should point out, and I think this was much of the discussion topside, that there are considerable outlays that interconnection customers are providing. Again, it's not just simply the initial study deposit. They have to secure financing. They have to demonstrate site control and commercial readiness, which might entail additional deposits. But fundamentally, and the reason why this is compensatory, not punitive, is that the transmission providers are paying good money for a timely study of impacts.
You mean the interconnection customers are paying?
Yes, the interconnection customers are paying for a timely study. Thank you, Your Honor. To the extent the transmission providers are providing an untimely study of system impacts, they are providing lesser value to the interconnection customer. Okay.
Can I ask you about this is a bit in the weeds, but the NISO issue for 205 filings where the stakeholder could prevent a filing? What's your response to that?
We don't believe that's going to be a problem, and we believe that the customers will be motivated to provide whatever supermajority vote that one particular system operator needs under that one particular tariff provision. Because I think everybody agrees in the value of a timely, transparent process. The transmission providers will have ample opportunity to make money once generators come online and become interconnected.
There's lots of people like nice things, but don't want to pay for them.
That, of course, is correct. If for some reason the 205 vehicle is unavailable to this particular transmission provider, we believe that there is another mechanism, Section 206. The transmission provider can come in and essentially file a complaint against this particular provision that perhaps doesn't allow them to make the contemplated filing.
They wouldn't need the stakeholders' permission to file the 206.
I don't think so, or certainly not the supermajority permission. And this has come up on occasion, not in this circumstance, but there have been other rate filings where the system operator files under Section 206 instead of Section 205.
Can I ask you about the network system versus energy system for affected systems? That's a lot of systems, if I got it right. If I didn't. Trying to remember exactly what Mr. Lynn said, but I think he said, look, maybe the status quo pre-2023 order was not terrific, but instead of kind of replacing one bad system with another bad system, there was a middle ground, and he described it, I think, as where the interconnection customer has asked for network service, then the study should be allowed to test for network service or firm service. Well, why isn't that correct?
Well, that is a possibility, but I do want to take a step back here. Previously, under our old rules, there was nothing as to affected systems. The commission in the new rulemaking added an entirely new Article 9 dealing with affected systems. As part of those new rules, the commission necessarily had to address the modeling of impacts on System B when there was a request to interconnect with System A. All the commission did here was to articulate, at least in the first instance, where there hadn't been any guiding rule, our preference for the lower cost energy modeling system as opposed to the network modeling system. The commission offered a number of justifications, and I refer to this court to.
I think I'm familiar enough with the good reasons for this reform. But you said a minute ago, I think you said something like maybe they could when I was describing kind of Mr. Lynn's proposal. So are you saying that if a affected system were to do that, after this order goes into effect, that might be allowed?
That might be allowed. The argument
consistent with, I thought that the 2023 order said you have to do an energy system study.
the commission will be receptive to whatever individualized arguments are presented to us. The new rule is the baseline default rule. To the extent any transmission provider believes that the default rules do not accurately capture the reality of circumstances within that region, the commission will be receptive to those
I mean,
arguments.
I think that's probably music to the ears of the transmission providers. But I can imagine Mr. Lynn when he gets back up here saying that what you just said is not what the order says.
Well, I've heard much skepticism from transmission providers about the processes that the commission has provided with respect to the energy versus network system. The argument that we received, I think from only one system operator, that was Southwest Power Pool, was that this is problematic because of the mismatch between the neighboring mid-continent system operator and Southwest Power Pool. And we addressed those arguments 3814 to 3820. But if there's anything that we have missed, or are there any new circumstances or any arguments that reflect the borderline between other system
So
operators?
you're just saying maybe this would be, maybe this sort of third way would be okay if it's put in a 205 filing and approved by FERC. Is that?
Yes, Your Honor.
Okay.
Utilities always have the right to make Section 205 filings.
And it would not, it's not obvious, you're saying it's not obvious that FERC would deny that on the grounds that it is in conflict with Order 2023. That's what you're saying.
It is not obvious.
Okay.
The commission has made a preliminary finding. It prefers the energy approach. I think there was a reference to the Tenaska case. Using the network approach can be prohibitively expensive and not provide a commensurate benefit to the interconnecting customer. The commission made reference to Mid-Continent, which uses the energy system, and found that there haven't been any documented reliability concerns. But if there's something more we need to know, we'll hear it, which leads me to the due process that we have.
I'm done. Thank you.
I want to hear about the process issues, but I want to understand something about how these studies work now that you have a cluster system. So the question posed is if one company wants network service on the affected system, then they can do a network system modeling. But I had thought, and I'm just maybe completely wrong here, that the whole point of cluster studies is that you have people grouped together, whatever criteria. So would you let's say there's one company in a cluster that wants network service and everyone else is good with energy service. Would the study, because they say, hey, I want network service, would the study then be done on using network service modeling, which is going to make both the study and the ultimate costs super more expensive for everybody in the cluster? Or despite the clustering, am I wrong? Is everyone getting individualized studies? I just don't understand how this, I want network, nobody else does. And so that's going to drive the study?
Well, the answer is yes and no. For purposes of the initial cluster, the degree of deliverability or the preference for network versus energy, I believe, doesn't matter. What matters to the annual cluster process is that you demonstrate all of the prerequisites. And the prerequisites are that you have demonstrated site control and demonstrated commercial readiness. But what this means is within the cluster, there are interconnection requests at various points of interconnection. The cluster is more a timing cluster as opposed to a geographic proximity cluster.
The cluster study I had thought was by the transmission providers, but it sounds like instead you're telling me the cluster study is a study of the interconnection customers?
The transmission providers provide the cluster study of the interconnection customers and their
Okay,
particular points of interconnection.
okay.
It's
At the facility study stage, is it all individualized then? I want firm service, I don't, those are all individual studies.
yes, facilities is individualized because you're focusing on the individual facilities of the individual customer. But the cluster study, cluster
Got
restudy,
it.
and the affected system study, they are all clustered.
Okay, and then was there a proposal in the rulemaking from Southwest Pool or whoever it was, anybody, that in fact, what the rule should be, what your default rule should be, if you request energy service, that's how the modeling will be done. If you request network, that's how it will be done.
I believe that was the request of Southwest Power Pool.
And why isn't the answer, since this is now an individualized study, why isn't the answer to that? Obviously, yes, it seems crazy to have someone do an energy service study when that's not going to be the service that's provided.
Because the commission was focusing on the perceived benefits of the energy study and focused on the potential mismatch that the interconnection customer will be paying for a
But there won't be a mismatch if you adopt a rule that says, tell them what you want and that's how it'll be modeled. If you want network, that's what's going to be modeled and you will be paying for that study and you will have to stick with that service. And if you want, there's no mismatch then. I mean, it seems like there was one mismatch and now it's replaced with another mismatch.
Well, we're starting with a uniform approach. Again, there wasn't anything before in the rules in the tariff as to affected system studies. We now have a big new article, Article 9.
I understand all that.
That's now the starting point.
I understand that's your starting point. So now there's something where there was nothing. But your answer to one mismatch was to impose another?
Well, we'll see what the transmission providers offer, if anything, to the commission. Right now, there is no mismatch. It is possible that
They
a
offered to the commission, why don't you make it a match instead of a mismatch? They offered that to the commission. I don't know why they wouldn't apply to everybody. I get that Southwest has its own sort of unique design, but why wouldn't?
Well, this is why we start with a generic rule, and then we provide for compliance filings, and we provide for individualized Section 205 filings. These are the default. This is the basic package of reforms that the commission believes are appropriate, but we're very sensitive to the regional and individualized concerns of particular transmission providers. This is especially true with respect to system operators, Mr. Lynn's focus. And we note that the system operators are similarly situated to the extent that they conduct the study and they have dominion over the system that they administer, but they're also differently situated. The commission recognized that cost recovery is a little bit different for system operators. So they're able to make compliance filings. They're able to make Section 205 filings on either a default or case-specific basis. Judge Millett, you asked questions about why they haven't done so sooner. There is nothing stopping them from filing sooner. Now, perhaps they want to wait until their compliance filings are accepted. Perhaps they want to wait until a year or two of this 3-year transitional process has elapsed, but they have the ability to make filings. There's nothing particularly new here. The commission in its rulemaking made reference to earlier rulemakings, in particular its Order 890 transmission service rulemaking and its Order 672 NERC reliability violation rulemakings. In those cases, We similarly insisted that the system operators be subject to these penalty schemes, but we offered this mechanism,
So,
the ability to file something else.
so if a system operator makes a 205 filing that changes a mismatch into a match, that 205 filing would be approved by FERC.
I think the commission would look favorably upon that because much of the concern is the mismatch as opposed to the match.
I think it's just called a match, but that's my fault.
I could have just said match.
But so, is the default rule there because that's commonly what people want is energy service analysis, or just so that it makes things go faster? Or, if the only one that's going to want this network service is Southwest, that's one thing, but if it's, and some of the rules, the explanation regarding it sounded like it was sort of a sui generis concern for Southwest, but I just don't know. It sounds like this is more a question of what the interconnection customer wants. And if interconnection customers commonly want network rather than.
I don't know what interconnection customers want, but I do think this is a sui generis issue concerning the Southwest power pool.
Listen, the commission described it, but I guess I'm just surprised. But what do I know about this? I would have thought there'd be
This
a variety of interests in different levels of service as they're offered.
What do you know? What do I know? Among all of the issues
You
presented,
know more than me on this.
this is the most technically challenging, the one that is most electrical engineering in nature. What is more legal and less electrical engineering is the good cause appeal process. Now, transmission providers are suspect. But there is a process already in place. The commission didn't have to spill more ink on the process. We already do have a process at 18 CFR 385.101. This is our standard rules of practice and procedure. The commission actually was quite detailed. The court, the agency.
What will govern penalty appeals?
Which will govern a penalty appeal. The commission.
Why did the commission say that? It's nice to hear it from you. Why did the commission say, when these people came in saying, how's it going to work? They go,
well, that's
the existing rule.
Well, that's why I'm explaining this now and hoping to alleviate some of the transmission providers' concerns. We did note that there would be a filing. We did note that there would be an order. We noted that that order is subject to agency rehearing, that order is subject to judicial review. Such an order has to be an on-the-record adjudication that fully explains itself, just like any filing or any proceeding under our general rules of practice and procedure. And we think this is what the transmission providers want. They claim that we've kicked the can down the road. We have not. We have been responsive to their concerns for some type of process that allows for them to argue individualized circumstances and regional differences. We have not acted in an unduly discriminatory manner. We have not acted in a confiscatory manner. Constitutionally, the transmission providers still have full opportunity to recover their costs. Indeed, this court in the 2007 National Association case approving the earlier rulemaking said that it was indisputable that the commission has the ability to disallow imprudent or unreasonably incurred costs. We don't think this is going to be much of a problem. We believe that the deadlines are reasonably attainable. We're not aware of any real problems with respect to those penalty schemes or cluster approaches or whatever that have already been put in place, but in the off chance that there is such a problem, the processes are in place.
You responded to this in your brief a little bit already, but the transmission petitioners say you approved PJM's new system on like Monday, and then on Tuesday you said it's not just and reasonable.
Monday and Tuesday are relative. As a practical matter, the approach that we approved in 2022 will be in effect for a number of years to the benefit of PJM customers. We also acknowledged in the 2022 order the pendency of this generic rulemaking. And we said we would consider the broader issue of reasonable efforts and timetables and penalties in that generic proceeding, and we wouldn't make any further changes at this time. So PJM and all of the transmission providers have been provided ample notice that the commission very well could adopt precisely the scheme that it adopted in these orders.
Any other questions? All right, thank you very much.
Thank you.
We'll hear now from the respondent interveners, Mr. Tom.
Good morning, Your Honors, or afternoon. Alexander Tom, on behalf of respondent interveners. May it please the court, I'd like to focus my time today just to clarify a few points. First, a couple of factual issues that I think go to the reasonableness and fairness of the system, and then a couple of quick legal points. So first, two parts of the who pays question that I think have been discussed today, but maybe not entirely clear. So I want to reiterate, as FERC's counsel said, that interconnection customers are the ones who pay for the costs of studies. And so FERC acknowledged that its requirements might require transmission providers to make additional investments, to dedicate more personnel, to invest in computing. And it said both in 2023 at JA 2085 and at JA 3645 in order 2023A, that those additional costs can be recovered from interconnection customers. And it also said, to their point that they may not be able to find additional personnel, that that is an extenuating circumstance that they can raise in an appeals process. And then on the question of who pays for penalties, the reason that interconnection customers don't pay penalties if they cause a delay, FERC addressed that as well. So at JA 3780, this is paragraph 458, it explained that if an interconnection customer causes a delay, for example, by missing some internal deadline, it can be deemed withdrawn. The transmission provider has that power. So it will be kicked out of the queue, it will pay a withdrawal penalty, and it will not be eligible to receive any of the redistributed late fees. And then it also said that if for some reason the customer is still in the queue, it could then, for instance, if there were multiple causes, the customer contributed some amount to the delay, it could reduce the penalty by that amount. And so again, that's the flexibility that FERC reasonably reserved to address different circumstances that could arise in the appeals process. Turning to just a couple of quick legal points, to the question about FERC's timeline to act on 205 filings, it has a tight timeline to act. So if a system operator files a default cost recovery proposal under Section 205, FERC has 60 days to act, or it takes effect by operation of law. So just wanted to yes, that's in the statute. And then I also just wanted to briefly clarify the affected system study issue. So the question is the level of, there's a difference between the level of service that's being requested on the host system and the level of service that is being used to model effects on another system. And so FERC points out in its brief at page 116 that the mismatch is actually that if you're using a network modeling service on the affected system, you can be basing your analysis on services that the interconnection customer would not receive. And that's also at JA 2261 in order 2023. And then finally, I just want to point to a couple of other examples regarding penalties that also operate without the Section 316A provisions. So FERC referenced the traffic ticket penalties. So these are not traffic tickets that we get for driving too fast, but mechanisms that FERC has approved in system operator tariffs. And if someone violates a provision in a system operator tariff, they get a penalty. They can either pay the ticket or they can file a Section 206 complaint with the commission, get an appeal in which the commission considers all relevant circumstances. And that's not, again, subject to the provisions that they say apply here. That's also true for the Order 890 penalties, where the commission required transmission providers who do those studies late to file a notification filing that serves a similar purpose as the appeal. And then it's also true in the PJM capacity market penalties, which council referenced, for example, in Winter Storm Elliott. Those are not assessed through the notice in the specific procedures that have been referenced.
Tom, can you talk a little bit about why Earth Justice has standing?
Yes, Your Honor. So to clarify, I work for Earth Justice, but my clients are Natural Resources Defense Council and Sierra Club.
Okay,
but
I do appreciate that. I was confused, but
just want to make sure that's clear on the record.
Why EDF and what was an NRDC have standing?
Yes. So we have standing as defensive interveners because our members will be exposed to increased rates if the rule is struck down. So FERC has. I'm sorry. Our members, and by our NRDCs and Sierra Club's members, are ratepayers across the country. For example, we provided declarations with our motion to intervene of ratepayers in PJM, in the MISO territory. The organizations themselves pay for electricity in the offices. I think there's an ample record here, FERC's findings about the increased costs of delay, the fact that it's stifling competition.
I thought that for associational standing, the injury had to be somehow connected to the purpose of the association. I don't think NRDC's purpose is to pay electric bills.
Well, so insofar as NRDC is paying its own electric bills, that's a direct injury to the organization. NRDC's purposes are to promote clean, affordable, reliable energy. And so the affordability component, and then I think as has been noted here and also in the record, the fact is that many of the resources that are in the queue that have been severely delayed in connecting are wind, solar, and storage resources that fit within our purposes.
I appreciate that.
Well, I would just add on that standing issue. Your standing argument is not in your opening brief. It's in your motion to intervene, which was only granted for leave to intervene. Is that correct?
Yes, Your Honor. So we are here as respondent interveners. We moved to intervene, which the court granted. And with our motion to intervene, we both provided argument on why we meet the test for intervention and also why we meet Article 3 standing, which this court's precedent still requires.
You said that if FERC doesn't meet the 60-day deadline for acting on a 205 petition, the petition just automatically takes effect. What are you citing for that?
So that's in the statute itself, and then it's not in the briefs, Your Honor. So this is section 205D and the way that it's been interpreted.
205D is in dog?
So 205D requires 60 days notice before a rate can take effect. There have previously been issues where FERC has been deadlocked and unable to act within 60 days. There were some reviewability issues there, and then Congress added a provision, section 205G, that provides if the commission is deadlocked, it's considered.
They're not deadlocked.
Yeah.
They just haven't acted in 60 days.
So this is that's an example of if they're deadlocked, and that deals with reviewability, but that is how 205D has been interpreted.
So 205D says it takes effect after 60 days, even if the commission's not deadlocked, it's not like in a quorum, there's not too many vacancies, whatever. If they just haven't got around to it.
Yeah, the rate is on file and then, and I'm sure FERC's counsel could speak to that as well, that they work pretty hard to meet that 60 days in every case or as much as they can.
And you mentioned earlier lower electric bills, but is that not a generalized injury for everybody?
Your Honor, so that's, I think, a different, there's a difference between a generalized and abstract injury. And so that's FEC v. Aikens. This is a 1998 Supreme Court case. The difference between a generalized abstract injury and an injury that is widely shared but concrete for the individual. And so these are concrete, particularized individuals for members who pay higher rates on their rate bill. See, I'm beyond time. If I could make one.
If you had one more, were you about to say you had one more point?
One quick point,
Okay.
yes, just on the takings issue and this idea that you have to be able to recover your actual costs. I would direct the court to the Supreme Court's Duquesne Light decision, which involves denial of cost recovery for millions of dollars in a canceled plant.
Thank you.
Your Honors.
All right. Mr. Shepherd, I think you said you wanted 2 minutes for rebuttal, and we'll round you up to 3. How about that? It's been a
Thank you, Your Honor. Thank you, Your Honor. I appreciate it and your indulgence earlier. I really want to emphasize how much I appreciate how very seriously you all are taking this, trying to get to the bottom of things. Excellent questions. And I think we're all going to get to a better place as a result of your review here. Several points just in seriatim, trying to sort of focus them by functional area. First, I need to make a correction. As I remember, I was very uncomfortable when you were asking me about whether or not anyone had proposed alternatives to reasonable efforts. As soon as I sat down, I was deluged with notes reminding me that I had signed a brief that page 73 of which points out that Midwest ISO, the New York ISO, and PJM did, in fact, all propose alternatives. One of them is like regular client of mine, so that was a heck of a mess.
There's a lot going on here, a lot in your heads.
But petitioner brief 73 has the citations for those, except the PJM one because it is CEG and needed the words back. But yes, people did in fact ask.
Do you happen to know what the proposal, any of those proposals were? Or I don't want to test your memory too much with everything going on.
They all had a theme, which was, can you just let us get here in a place that's not going to cause us to have to like lose our actual costs? We think we have alternative paths, and FERC was not tempted. I don't think that any of them had any other particular similarities. So there that we are. But I know that was important, and I really wanted to correct the record there.
Thank you.
I appreciate this theme that Bob is pushing about the idea that someone paying for a timely study. I think it's a little bit more important they're paying for an accurate study. Your Honor was talking about the difference between champagne and sparkling water. That's what's happening here. This is a high-end request for a very high-end service. This is not Domino's doing a pizza delivery thing where, if they're 30 seconds late, you get one free. This is not a marketing ploy. We're trying to connect billions of dollars of infrastructure and trying to get the cost allocation right. If we screw this up, lights go out. That's bad. People die. I'm not trying to be hyperbolic. I'm being very serious. Yes, everyone wants something on time. No one is saying that they are happy when things slow down. I tried to explain before, especially wires TOs and RTOs have every incentive on earth to get these things done as quickly as possible.
So what's a wire TO?
Wires only, transmission owners. Sorry,
Okay.
When I get in a hurry, I need to use the jargon. So I'm talking about like the entire Exelon family, wires and distribution now. All of First Energy except the piece in West Virginia, wires. PPL, wires. It's becoming a kind of dominant thing. FERC proposed, functional unbundling back in the 80s. Now it's actually like physically unbundling. Okay. So we have things other than vertically integrated utilities now. On the question about whether or not this is punitive. Right. Last pass at this point. The penultimate paragraph in Kokesh deals with the question of whether or not, or deals with like the feature that I think is most clearly makes the penalty, regardless of whether the money goes to the Treasury or that goes back to someone else. That may be a compensation for them. Either way, it's a loss of money for us. But very importantly, in the penultimate paragraph of Kokesh, they address this question.
right? And as demonstrated by this case, SEC disgorgement sometimes is ordered without consideration of the defendant's expenses that reduce the amount of illegal profit. We actually quote this in our briefs. I just really want to bring it to your attention here. They then go on to cite the third restatement of restitution. And then in such cases, disgorgement does not simply restore the status quo. It leaves the defendant worse off, and that's punishment. And that's what's happening to us. We provided them a study. We lost our investment in that study. We paid these people to perform the study, then had to pay these people what we paid these people. And so we are in fact worse off. So it is clearly for us, it is clearly punishment. And not just because we didn't earn something, but because we lost something. I really think that makes this a very important difference that overshadows the possibility that under Kokesh, that maybe it would go back to the person, maybe go back to the department, maybe it wouldn't go back to the, I think it overwhelms that point entirely. Next, I'm very happy that Bob started talking about Appendix B. I'd waved it around a little bit, and I'd really strongly encourage you.
Just be better to say
sorry.
your friend or Mr. Solomon. I know
My very good friend, Mr. Solomon.
Very
Yes.
well in the casualist, but for the record.
Thank you, Your Honor. I appreciate the correction.
Bob was. It's my husband's name too, and I'm like, what?
Oh yeah, that would be bad. So what this shows, what Appendix B shows, because it breaks down how many times you have late break. This is JA 2587 and on. This is where all of the numbers are listed for who was late how many times.
Okay.
So it persists through 2592. It consists of 4 tables. It's broken down by which RTO we're talking about, and then it breaks it down by which TO we're talking about. And so a point that I would like to dwell on more before, but I'm glad that he's opened the door to come back to it, is please note that, as we emphasized in our briefs, 87% of the violations upon which FERC based this national order came from one RTO. Within that RTO, more than 80% of the queue takes place in 2 utilities that share Southwestern Virginia. Please look at the trend lines on these, because the trend lines are basically good. CAISO down to zero, repeatedly down to zero at the end of the year. When we pointed this out to them, their answer about the fact that, like, would you have done this if 87% of the numbers were different? Because FERC left PJM in knowing darn well that it had just approved them to change. And then they took SPP out, and SPP had good numbers. So we were a little peeved that the evidence seemed to be manipulated to make the problem even worse. We're not saying the position's great, but to come back and say that if 87% of the evidence went away, that we'd be in the same spot, that's really hard to take. What this appendix shows is a wild.
I think we're familiar with the appendix. You referenced it many times.
Okay.
And
Yes, ma'am.
your brief talked about this.
Yes, it did. It sure did.
The PJM stuff.
Right.
So no further questions from my colleagues? I'll give you one sentence. Don't inhale.
There's no such thing. We cannot file a 206 to overturn a rule set forth in FERC's order. As Mr. Tom said, that is simply not true. If we did, that is going to absolutely be thrown back as a collateral.
Thank you.
Sorry. There was a semicolon in there.
Thank you. All right, Mr. Lynn, we'll also give you 3 minutes. But can you ask again? Can I ask a factual question? I'll try to go quickly to not take.
Of course.
Here. It sounds to me like some operators can sometimes assign a particular transmission or maybe multiple transmission members to undertake the studies themselves rather than the system operator doing it. How often is it the system operator is the one actually doing this study as opposed to assigning it out to maybe the most relevant transmission providers?
I don't have a percentage for you, but I don't think it's like 2% versus 98%. I think it's not in the record. So they do talk about in the record how, in cases where I think a transmission provider member is directly responsible and any penalties incurred will go to that transmission provider. But there's nothing, so far as I know, that
one way or the other
breaks down the percentage. I think our answer to that is, look, that's good and well for when it happens, and it will reduce the situation.
Well, if it happens most of the time, if this is a rare bird, that's a different way of. I'm just trying to understand how to think about that.
I think the answer is it's not something that's like almost all of the time. I think everybody agrees that there's some
almost never
mix.
Mix.
I think most I'm comfortable saying at this point is it's a mix.
Okay.
The one thing that I wanted to try to convey on reply is there is sort of a theme that runs between the two arguments that I'm here addressing, and it really boils down to is the availability of a 205 an infinite end run that FERC can turn to and say, there's a 205 available, and therefore this problem that you're facing is not really a problem that needs to be addressed today. And I think the answer to that is yes, it makes sense for individual circumstances. And my friend said that a lot of times there's always the opportunity, and as they acknowledge, a 205 is always available. So the answer, it can't be that they can always solve the problem that is raised to them by pointing to the 205. There have to be limits. And I think, at least for the two arguments that I'm raising, there are two relevant limits. As for the dissimilar situation of the system operators, again, I think the answer to that is that is a question that goes to the heart of the statutory authority that they are exercising. And if I just really quick could point you to the Maryland People's Council case versus FERC 761 F. 2nd 768. And what it says is, while there may well be circumstances where a particular objection is more properly deferred to a later proceeding, that is assuredly not the case where the objection goes to the heart of the public interest determination immediately to be made. And our contention is that, explaining why the replacement rate, which is what they're doing here, is not discriminatory, is the heart of the determination that's being made. Mm-hmm. As to the network service, energy service.
I'm so sorry. I know you're.
I'm sorry.
I will let you make the second point, but replacement rate?
Well, so what they do in the 206 context is they say it's rate or practice, right? They say what's happening now, I think I use rate, right? Right? What's happening now is, and so we're going to do something in its place. That's what I mean by replacement rate. And so I think that's the heart of the question that's immediately being decided. So 205 can't be a get out of jail free card for that. On the network service and energy service, again, they invoke 205 as sort of the answer to that. And they say, well, you can come to us and you can say, how, we really want to do network service when the interconnection customer asks for network service. I think, again, there's got to be a limit there. They're saying it's going to be looked on favorably, and we're very happy to hear that. But I think an example is, Your Honor, you referenced the PJM compliance filing that they have ruled on. And they said there, we are rejecting your effort to continue the reasonable efforts standard because that is a collateral attack on the order. I'm glad to hear my friends say that FERC's going to look favorably upon this, but 205s are not used to contradict the rulings that they've squarely made in the order itself.
And can I,
Yes, Your Honor.
if someone says to, because this is only as to affected systems, affected system, I would like network service, and put this rule aside, so a pre-rule system, I would like network service. And they go, great, we're going to model network service. You're going to pay for this study, and the study will tell you the costs of this super duper service. And that all happens, is the affected system then obligated to provide that network service that was studied? And tell me if the answer is different for jurisdictional and non-jurisdictional affected systems.
The answer, I believe, is no, because the question that the affected system is analyzing is not their providing network service to the interconnection customer. It's the effect on their system B of system A giving the interconnection customer network service, right? So what's happening here is the interconnection customer is going to system A and saying, hey, I want network service or energy service. Mm-hmm. And then system A says to system B, this could affect system B, and system B says, okay, I now need to do a study that figures out what the reliability impacts are going to be on my system from A providing the service that is requested. So B is not, this is not
from A providing the service to the interconnection.
Correct. Yes, Your Honor. And so if the interconnection customer wants energy service from A, then B will do an energy service study. If the interconnection customer wants network service from A, then B wants to do a network service level study because the impacts are going to be greater because these, the wires are all connected, right? And so if
I'm not sure why I get that, because the only point of network is almost like a prioritization thing, but some power is going to be coming through, whether it's paid for by the Champagne people or paid for by the people on standby that come in when there's nothing there. It's going to be the steady flow of power coming through to the affected system. And so now, because I thought your point was, if someone says to the affected system, I want network, because that's the only one that's required to do the energy service study. I want to do network service with you, then we should be able to analyze it that way. But now what you're telling me is if someone says, I want network service all the way through, obviously I've already told up front here on the, what do we call it, the main line, the host, whoever you call it.
yeah, the host, that might
Okay,
work.
the host one. And so you're going to give me this super expensive study, and I'm going to go and that study is going to be for, here's the cost of all these upgrades I'm going to make so that I can, wait, this is what it would cost. And then you're not going to get it. So then that's sort of takes a lot of the air out of your argument.
No, so the difference is if one system, again, let's call it A, is providing network service to an interconnection customer, that means it's firm service as opposed to interruptible service. That's going to have a greater impact on the neighboring systems because the transmission wires are connected and the electrons go where they go, right? So A is the one that's guaranteeing that there will always be transmission because it's firm as opposed to interruptible. But the concern is that when that kind of service is provided on system A, it's really, as I understand, again, I'm neither a FERC nerd nor a physician, or a physics major.
Or a physician, or maybe.
Or a physician, not even that, or a physics major. But as I understand it, the issue is when you provide non-interruptible service in one area and they're all interconnected, the effect on the neighboring system is greater because the electrons are non-interruptible, and then they're sort of, they will flow where they flow, and they can flow into the neighboring systems. And again, maybe this is the better way to answer your question. FERC admits that when an affected system uses an energy service standard to test the impact of network service on system A, it will not catch as much. And so that's ultimately the issue here.
Will not catch as much.
In terms of the impacts, the reliability impacts.
How much is the differential?
I'm not able to
Nothing in the record about
quantify it. Yeah, I can't quantify the difference. But again, FERC agrees that that's true. And their answer to that is, I think, as I said before, you're going to have a second opportunity.
If it turns out to be material impacts, but in fact, if it's not material impacts down here, because those folks aren't going to be providing network service, I guess lots of, as you said, ions will be coming in. But if it's not going to be that much material impact, then if we don't know how much the impact is, it's hard to know why this across the board rule.
Well, I think I'm sorry, Aaron, I think the point is that it's enough that FERC's answer is not these impacts are so small that it's not really a problem. FERC's answer is it's okay because the way these things work is there'll be a second opportunity for the affected system to catch sort of the additional impact problems. And as the brief explains,
that seems to assume that answer, that this isn't going to be an across the board crippling problem, because why would they adopt such a silly regime? And so if they understood the complaints to be sometimes this can be a problem, or sometimes the impact, the differential will be so big, it's going to be a problem, but not all the time. Then that's the type of thing is I find if you can show us you've got an actual real problem here, come let us know. But as of now, we think we've got to balance a lot of interests here. And yeah, there's going to be some difference, but it's not going to make that big a difference.
Yeah, and it comes back to my response to you earlier, which is they acknowledge that it will be a problem in some cases, and the answer to that is going to be a 205, and the 205 is to ask for something that we have already said you're not allowed to have, and that is ultimately our complaint, is that it's an illusory safety valve, right? 205s can be useful safety valves in lots and lots of situations, but it's not appropriate for the system operators because the burden is on FERC to answer the question. It's not appropriate here because it's illusory, because they're just going to tell us, as they did to PJM recently, your attempt to do what we said is unreasonable.
That's different. That
is a
was-
collateral
that was-
attack.
We want to just get rid of this entire reasonable effort thing. The whole purpose of the rule was, but when they have said in the order itself, look, if this is a real problem for you, for an individual, we think this works on balance best for everyone across the board. But if you can show us that for you as an individual, we need to make some adjustment or tweaking, that's 205.
And Your Honor, let me make this very clear. If this court wants to write an opinion that notes that FERC has said this and that they are going to take this seriously and that they can provide us with something that seems to be squarely at odds with what they've ordered, we will take that.
Can I ask
Yes, please.
one question? I know we're it's 12:53, but do you have FERC's brief?
I get it.
They just wrote one sentence that I wanted to see if you agree with, or see if you understand better than I do. It's page 116 on this topic of network service, energy service. Okay, so it's the second sentence of that first full paragraph. More specifically, network service models often result in significant network upgrades on the affected system funded by the customer, but that customer does not receive the guarantee of top-tier network transmission service in return. The affected system provider can block or reduce delivery of the customer's output. Setting energy service as the default model prevents this instance. So does that affected system provider can block or reduce delivery of the customer's output?
I think that what that's getting at is the same question that Judge Millett asked, which is the affected system providing the network service, the uninterruptible service, or is it providing interruptible service, essentially? And the answer to the question is the affected system is not required to provide the network service. The network service request is made by the interconnection customer of the host system, System A. But again, irrespective of whether System B is providing higher level service or lower level service, the issue is that the impact on System B is higher when System A provides networks.
Can System B do anything that would prevent the interconnection customer from receiving network service from System A?
No.
Okay.
Thank you, Your Honor.
All right, the case is submitted, but thanks to all counsel for helping us with this. Oh, I'm sorry, we're not, nope, back on. All right, I withdraw my thanks. I apologize.
No, I promise I'll be quick. I know I'm standing between everyone here on lunch. On rebuttal, I just would like to address 2 points. First, the fundamental assumption that we're discussing here, and then FERC's misreliance on the PacifiCorp, Tri-State, and PSCO cases. So, one, the fundamental issue here is actually when the interconnection customer will make the decision as to whether or not to withdraw. Not if it will withdraw, but when it makes that choice. If the project becomes economics, there's nothing that the penalties can do to change that. What the penalties do is just say, hey, we already know you're economic, but you also have to pay 10 or 20% more. So that is what is at issue
Do you
here.
disagree with the point that almost all affected systems are either jurisdictional or have these reciprocity agreements where they're going to comply with these deadlines? You're not going to be forced to file your LGIA, your agreement, large generator agreement, until after, if you wish, until after you have the study. So this really is a vanishingly small set of situations where you're going to have a problem at all, a delayed study by the affected system at all, let alone one that has such extraordinary dollar impact on it as to make this a huge problem for, make it some sort of huge arbitrary and capricious problem for them to say, well, who's going to bear the cost of this?
It doesn't matter what I believe. It's a matter of what FERC said in footnote 9 of its brief, in which it says, it notes that affected system studies can come in late. I'm not entirely.
I am asking not what you believe, but what you know. Is this a real problem, how often is that? There's one example, okay,
Right.
pre-rule. But if this is sort of, are we asking whether the freakish situation should wag the dog here? That's a different argument you got to make than if this is a recurring and crippling problem in reality.
I'll again point you to footnote 9 of FERC's brief where they point out that there is in fact a problem. So then moving on from that, just quickly to address the misreliance on the non-RTO cases, Tri-State, Piesco, and PacifiCorp. As I just said, they're non-RTO cases and FERC relies on those for the 100% as the threshold for host system withdrawal. So in order
It doesn't matter whether they're non-RTO or an RTO for purposes of the withdrawal penalty.
the scope of the problem. In the NOPR, at the end of the NOPR, there is a table attached to it.
RTOs are all going to be jurisdictional and subject to the same protections I've already discussed with you.
As are the non-RTOs, but what we're looking at is the scope of the harms that we're trying to protect against, and then what one of the RTOs said themselves. So JA 0335, there is the table of delays. It shows the RTOs that are significantly more delayed and significantly more projects at that time.
Pre-2023.
Pre-2020, 2023, but there's, so it's that. It doesn't necessarily change the number of projects going in some instances, but anyway, so these are much larger and they're going to be much larger queues because these are much larger geographic areas. Piesco covers part of Colorado, Tri-State covers part of Colorado. PJM covers 13 states. So with respect to that, FERC looked at these small regions and said, this threshold should apply nationally, which is strange because in the NOPR proceeding itself, MISO, which already had a withdrawal penalty threshold of a per megawatt amount, actually suggested that their version of it works. And they're suggesting it after Piesco and PacifiCorp had already been in place and had already been noted in the NOPR.
Okay.
So with that, that's it.
All right, thank you. And now I will repeat our great thanks, if I can speak on behalf of my colleagues, our great thanks to all of you for assisting us with all the issues in this case, and the cases submitted.
It's honorable for us now, very much. Number 30, 2008.